May I
Yes,
please, my lord?
please.
My lord, I beg to mention item number 11 and 12, my lord. So this matter may be allowed to withdraw with liberty to file a press, my lord. 11 and 12, my lord.
11 and 12.
Yes, my lord.
You are Mr.
N. Rama, my lord.
Mr. N. Rama, the learned counsel appearing for the petitioner submits that he would like to withdraw the instant petition. The instant petition. Prayer is allowed. Let the matter. Prayer is allowed. The matter is closed on withdrawal.
Sir, I'm for the state.
My lord, on liberty to file a press, my lord.
The petitioner is given liberty to file a press petition.
Much obliged, my lord.
My please, my lord.
11 and 12. No? Same order, 11 and 12. Yes.
My lord, 2AB has been is filed this morning. Therefore, my lord, I am praying to take up this matter at unlisted item today, my lord, at 2.
Which one?
My lord, anticipatory bail.
Mhm.
2 anticipatory bails has been filed this morning.
Mhm.
Therefore, I am praying before the lordship to take up the matter as unlisted at 2 today, my lord.
2 will be difficult. I mean, we'll see like when it can be taken up. We'll take it up.
Oh, bless me.
My lord, I'd like to mention item number 20.
20. Yes.
Yes. I'm seeking for adjournment on behalf of J. Jenny. The conducting counsel is out of station.
The learned counsel so appears on behalf of J. Ginny, submits that the learned counsel is the leading counsel arguing this matter is out of station. Prays for adjournment of the matter. Let the matter be fixed on
After 4 weeks.
23rd of January.
My lord, I beg to mention one unlisted matter to be listed and heard today.
What matter?
Criminal revisions matter.
Why? What is the urgency?
The convicted already convicted already under section 420.
So what is the urgency there?
Now, accused is under judicial custody. Yesterday, Your Honor, actually yesterday I have filed that petition, but it could not be listed due to some clerical mistake.
Okay, we'll take it up if time allows. Otherwise, tomorrow. Do we have a fixed matter?
May I, my lord?
Much obliged.
I beg to mention item number 10 on behalf of K lawyer. Here, my lord, service upon respondent 2 and 3 are still awaited. So kindly 3 weeks time may be granted, my lord.
Lord Mr. So-and-so submits the service on respondent number 2 and 3.
3.
2 and 3 are yet to be completed. He prays for listing of the matter in the first week of January.
My lord, 3 weeks time may be granted.
Prays for listing of the matter after 3 weeks. Let the matter be fixed on 29th of January.
My lord, in here we are supposed to file a counter affidavit.
You file it.
And my lord, there is an interim order.
Interim order so passed earlier shall continue till the next date of listing.
Deeply open.
My lord, I beg to mention item number 19 on behalf of Upada.
Item number 19.
19, my lord.
Yes.
But council is out of session, my lord. So council is out.
I heard Mr. So-and-so. He submits that the arguing counsel in the matter is out of station. Prays for adjournment of the matter for 3 weeks. Let the matter be fixed on 30th of January.
Lordship, I beg to mention item number 21 on behalf of conducting counsel T. Tagum for the respondents.
In this case, I am here, my lord, for the petitioner.
You don't have any issues?
No.
Mr.
L. Tikak.
L.
Tikak.
Tikak, the learned counsel appearing for the respondent. Submits that with the consent of the other side, he's praying for how much time?
4 weeks.
Hmm?
4 weeks, my lord.
He's praying for 4 weeks time. Prayer is allowed. Mr.
23rd, my lord.
Mr. B.K. Singh appears for the petitioner. Let the matter be fixed on
23rd of January.
23rd of January.
Obliged.
Your Lordship, I would like to mention item number 6. It's a criminal petition jointly filed by the alleged accused person and complainant. Your Lordship, I would like to withdraw the petition as instructed by the petitioner. I'm for the petitioners.
Okay, Mr.
Y. Tamin, your lordship.
Y. Tamin, the learned counsel appearing for the petitioner submits that he would like to withdraw the matter on instruction. Full stop. Prayer is allowed. The petition is closed as withdrawn.
Much obliged.
Lordship, I want to mention item number 3,
3.
Yeah.
Yes.
and the leading counsel is out of station. An interim order may be continued.
Heard Mr. So-and-so, he submits that the leading counsel in the matter is out of station. Full stop. And therefore, he prays that the matter may be listed after 3 weeks. After 3 weeks, prayer is allowed. Let the matter be fixed on 28th of January. 2/8.
Lordship, also item number 22 on behalf of K. Lolen.
Item number 22.
Yes, Lordship.
So appearing on behalf of Mr. K. Lolen submits the matter should be adjourned for 3 weeks.
An interim may be continued.
Prayer is allowed. Let the matter be fixed on 31st of January. Interim order so passed earlier shall continue till the next date of listing.
Obliged.
My lord, I would like to mention item number 16 as
16.
the leading counsel is on medical emergency.
MS, you are for the petitioner.
Yes, my lord.
MS so-and-so, the learned counsel appearing for the petitioner submits that the leading counsel in the instant case is having some medical emergency. Therefore, she prays the matter to be listed after 3 weeks. Prayer is allowed. Let the matter be fixed on 3rd of February.
My lord.
3rd of February.
16.
3rd February.
Your Lordship, also in this matter, we have not received the CD. Your Lordship may call for the updated CD, Your Lordship.
MSJ Genie, the learned counsel, learned APP for the state submits the CD in the instant case is yet to be received. Call for the updated CD in the instant case.
Much obliged.
Your Lordship, I beg to mention item number 7. I may be allowed to withdraw the petition.
You are Mr.
W. Tinkhatra.
Huh?
W. Tinkhatra.
You are not there in the case.
Uh,
Item number 7.
Yes, Your Honor.
You are appearing for whom? Petitioner.
Yes.
But your name is not there in the cause. I mean,
I'm representing. I'm on behalf of T. Don.
but you are withdrawing it.
Yes, Your Honor.
Mr. So-and-so, the learned counsel, appearing on behalf of Mr. T. Don, the learned counsel, learned counsel for the petitioner, submits that he has instruction to withdraw the matter. Prayer is allowed. The matter is closed as withdrawn.
Item number 1.
Your Honor, in this, I would like to withdraw the petition due to technical defect, my lord.
Okay, learned counsel.
With liberty to file fresh new.
MS So-and-so, learned counsel appearing for the petitioner submits that there is some inadvertent error in filing the instant petition. Therefore, she should be allowed to withdraw it to file a fresh. Prayer is allowed. The matter is closed as withdrawn, with the liberty given to the petitioner to file a fresh petition.
Yes, Your Honor. Much obliged.
Item number 2.
My lordship. Lordship, this is a joint application for quashment of charge sheet dated 15/2/2020, arising out of Itanagar PS case number 124 of 19 under section 201, 279, 304A, Lordship.
You have the earlier cases where this order was passed.
Yes, Lordship.
They give you the orders. You have it with you.
Yes, Lordship has recently 12 of
Yes,
this month.
yes. Like, I mean, we'll have to look into that.
Yes, Lordship.
You give me both the judgments.
Oh, it's one. It's one. Same.
Page number 52 of petition is a money receipt, Lordship.
No, there is some difficulty. I mean, this court has passed this order following the order passed by the learned single judge.
Yes, Lordship.
But in case of rash and negligence, when the person is died,
Yes, Lordship.
I mean, situation may be little bit different.
Yes,
I mean,
Lordship.
it's correct that this court has also passed, relying on the, judgment passed by the earlier bench. But we'll have to look into the matter. Yes, Mr. PP, what is your, opinion on this? See, this is a rash and negligent driving.
Yes, Lordship.
Person has died.
Yes,
The person is no longer there.
yes.
Only because some compensation has been paid, whether this can be compounded.
Lordship, since
See, rash and negligence, it's not like a simple injury or like somebody has suffered an injury.
yes,
It's a case of death. The victim is no longer there.
yes,
Correct. And this has some impact on the society. It's not that it doesn't have an impact on the society.
So 40s they have already settled.
Yeah, no, settle is, you do certain, criminal activities, which is, and wherein a person has died and you pay some money and you convince the family of the person, then whether that, in that situation, the case can be compounded or not, there are some issues.
yes. Lordship, in that case, Lordship, TCR may be called for. In the meantime, we will find a relevant.
Because, see, last time, this court has only passed an
Yes,
order,
Yeah.
relying on the other
Yes,
order.
I'm aware-
But
aware of-
now, when I was going through the case, then I was just having, it has to be considered,
Here in the case, Lordship, both the parties, every party, they are relatives, Lordship. And they
No.
have already,
they are not relatives.
No, no.
no, Lordship, they are from same community and
They are not relatives. They are not
And,
relatives.
this is victim and the accused person, they are from same community, Lordship. And with the intervention of the senior members of the community, they have agreed to settle.
Correct. A person has died. He is no longer there to give any comments. Correct.
Lordship.
And then his family members is
Yes.
taking the money.
Yes, his missus,
And
his wife only.
Somebody has died out of rash and negligence.
Yes, Lordship.
Negligence act of one person.
And in marriage also, Lordship, in deposition, his.
That's what I want to see. What are the depositions?
Yes, Lordship, I have already annexed the deposition of deceased, wife of the deceased. Lordship.
Lordship, may I have the record may be called for, Lordship.
46, page number 46, Lordship.
Hmm?
Page number 46. This is a deposition of the wife of deceased, Lordship, victim deceased. And on cross-examination, Lordship. Last part, Lordship, cross-examination.
1 second.
It is true that the case has been settled.
1 second. Page 45 is who, but
46, Lordship.
45 is who?
45 is
Complainant.
complainant, Lordship. Here also cross-examination, Lordship. Last part.
You can see how it was also told me that he was dragged from 0 point to 1.5 kilometers.
Yes, almost 2 kilometer, Lordship, drag.
All the Lordship on cross.
It's a hit and run case, Lordship. And the driver is also not engaged employee of this Lordship, this officer, Lordship. Without consent of this vehicle owner, Lordship.
And the agreement is between whom?
Lordship, all the parties.
Hmm?
All the parties.
All the
Accused
parties
person-
means?
Yes. Petitioner number 1 is a accused person, Lordship, and petitioner number 2 is also accused.
The petitioner number 1 is the driver.
Yes, Lordship. Is the person who has dropped the car. And petitioner number 3 is a wife of this victim. And 4 is an informant. And 5.
Who is 2? Who is 2? In the agreement.
Yes.
Agreement. Teki Dokum is the informant.
Yes, Lordship. Petitioner number 4.
Informant is the brother-in-law.
Yes, brother-in-law.
And this Dahi Sango, informant number 2,
Yeah, he is the owner of the vehicle, Lordship.
owner of the vehicle.
Yes, Lordship.
He also filed an FIR.
Yes, he has filed a FIR informing that his vehicle has been missing.
Vehicle has been missing.
Yes.
And this is the wife. And Machu Londa is the accused.
Yes, driver. Man.
Accused number 2, who is accused number 2?
Accused number 2 is Salang Songchalodio.
So he was
Yes,
sitting in the vehicle.
Yes, he was sitting in the vehicle also. Basically, he has no role at all.
And who has paid the money?
Both the accused number 1 and accused number 2, Lordship.
What does he do there, accused number 1?
Lordship, he's unemployed now, Lordship. At that relevant point of time, he was a part-time driver, Lordship.
How he managed to pay so much of money?
Lordship, by all the relatives and family members.
We'll take up this matter tomorrow.
Lordship.
We'll fix it tomorrow. We'll just see what can be done.
Yes, Lordship.
Heard Mr. So-and-so, and counsel for the petitioner, also heard Mr. D. Loy, the learned PP for the state. Let the matter be fixed tomorrow, that is on 24th.
Deeply obliged.
Yeah.
Item number 8.
Please, Your Lordship. See, this is a bail application filed under for section 483. This case in connection with POCSO case number of 07 of 2025. ITA PS case number 54 of 2024. Here, section 8 and 12 are not that punishment is severe. It is 3 years imprisonment or may extend to 5 years. And alleged accused person have already spent more than 14 months in a jail. He was arrested on 14/10/2024. And the evidence of victim, the victim's mother was an informant.
Anybody is appearing for victim?
For the,
You are.
We have earlier sent notice, but none of them have appeared.
I've been appointed by this one. I've been
He is appearing.
Yes, yes. So I pray Your Lordship to allow to accused to go on bail because the victim's evidence is completed. And informant evidence is completed. Even the IO evidence is completed. There is no now chance of any hampering. Annexure 4, page number 18 to 29 is the deposition, copy of the deposition. So the victim, informant, and the IO of the case. All have been recorded.
Has gone through the records, man. Even record discloses that the LGP's person is also suffering from HIV positive. And in addition to that, my lord, I've gone through the record, which discloses that the compliance requirement of section 47 and 48 has also not been complied in this case. And he has been under custody since more than 400 days, man. Therefore, with all fairness, my lord.
But allegation is, I mean, not only against the one victim, but against the daughter also.
Yes. Allegations are serious.
Yeah,
But now, the trial.
Your Lordship, here alleged
You say three years. I mean, under which sections?
section 8. Section 8, Your Lordship. Section 8 is punishment for sexual assault. Whoever commits sexual assault shall be punished with imprisonment either prescription for a term which shall not be less than 3 years, but which may extend to 5 years. And Section 12, Your Lordship, is punishment for sexual harassment. Whoever commits sexual harassment upon a child shall be punished with imprisonment of either prescription or term, which may extend to 3 years, and shall also be liable to fine. So here there is no about offense under penetration, Your Lordship. And he have spent more than 14 days, Your Lordship. That is about 400 days, Your Lordship. Evidence of the victim, complainant, or the relay have also been examined, completed.
Lordship, deposition is at 21, Lordship, page number 10, 21, Lordship. And operating portion is, Lordship, 22, Lordship.
You were arrested on which date?
Your Lordship, I was arrested on 14/10/2024.
14/10/24.
2024. Yes, Lord.
So how many days now you are behind the bars?
I have been more than 430 days, Your Lordship.
430 days.
Approximately, there is more than 14 months.
Yes, Mr. Loi.
Yes, Lordship, he is not only, he abuses her Lordship, but he is also, Lordship, a drug user, Lordship. So if he is released on bail, Lordship, there is possibility of, again, harassing the Lordship, this victim, Lordship. Lordship may kindly come to the page number, kindly come to the page number 22, Lordship. This statement even not fit to read out in this court, Lordship.
Page 22.
Yes,
What is there?
Lord, page number 22, an extra Lordship. From the top, Lordship.
Yeah, that is there.
That is
And
the allegation in the statement given by the victim.
There is consistency in her statement, Lordship.
And here, Lordship, prolonged delay, the delay of the trial of the case.
now how many, I mean, I think four have been examined. Three have been examined.
I think some few evidence witnesses left, but the relevant evidence, the important one, the victim, complainant, they have already been examined. There is no any temper hampering. Already he was in custody for more than 400 days. And your Lordship is aware with the case of Sanjay Chandra versus CBI. Long delay in trial. The accused had a right to go on bail. If after completion of trial, if he finds court proves that, then he will be convicted. But at that time, he have already spent more than 400 days. When should be granted, Your Lordship?
Where is that HIV report?
HIV, my lord, it's in the forwarding one, my
Hmm?
lord. It's in the forwarding.
The forwarding.
I make. Down below, if my lord allows me, I'll just point out this.
1 second, just.
And your lordship, if say he is suffering from HIV, it is a very serious disease. Other inmates can also be infected. So he may be released on bail and medication may,
How other inmates will be infected?
it's a communicable disease, your lordship.
It's not otherwise communicable disease.
So your lordship, he may take proper medication, which is not
It's already 430 days inside. I mean, it's only assault. It's
no
it's
offense of
8 and 12, correct? Another thing is that 430 days is already there. Maximum punishment is 5 years. Victims have been all victim, informant, as well as IO has been already examined.
Lordship, that's true, but Lordship, since the accused, informant, and the victim is residing in the same quarter, Lordship, even if it's released on bail, Lordship,
Strict terms.
With strict terms condition, your lordship. Bail can
Heard Mr.
A. Bhattacharya.
A. Bhattacharya, learned counsel appearing for the accused applicant, also heard Mr. D. Loi, the learned PP for the state, as well as Mr. For amicus curiae appearing in the matter. Full stop. The gist of the allegation as alleged in FIR dated
FIR dated 14/10.
2024.
Oh, sorry, your lordship. 7/10/2000.
Where is the FIR? I mean, 1 second.
FIR is page number 12 to 15, your lordship. On 7th October 2020.
7/10/2024. 7/10/2024. Is that the minor daughter of the informant was sexually abused by the accused applicant, who is the stepfather of the minor victim. Full stop. It was also alleged that the accused applicant had sexual intercourse with a different lady in front of the minor daughters. Full stop. It was also alleged that the accused applicant is a habitual offender and on several occasions he was found to be sexually abusing his minor stepdaughter. Full stop. On receipt of the FIR, the police registered a WPS case number 54/2024 under section 74/75/79/126 BNS, read with section 8/12 of POCSO Act 2012. Full stop. After investigation, the police filed the charge sheet and the matter is and the trial in the matter is being conducted before the Court of Special Judge POCSO UPA. Full stop. The learned counsel appearing for the accused applicant submits that the accused applicant was in fact arrested on 14/10/2024 and he is behind the bars for last 430 days. He further submits that the accused applicant is suffering from HIV positive and HIV positive. Full stop. He further submits that he submits that during the trial, the depositions of the victim, the minor victim, the informant, as well as the IO in the instant case have already been recorded by the trial court. Trial court full stop. He submits that in view of his long incarceration, as well as the fact of the depositions of the vital witnesses have already been recorded. There is no further requirement of detaining him inside the jail. Therefore, he submits that taking into account those material facts, this court would allow the accused applicant should go on bail. Full stop. The learned PP, on the other hand, submits that there are serious allegations against the accused applicant, as well as the statements, as well as the depositions revealed his involvement in the crime, so in the offense so alleged in the FIR, and there are possibilities that the accused applicant, in the event of his release on bail, try to influence and temper the evidence, involved in the instant trial. Full stop. Therefore, he opposes the bail, opposes the prayer for bail. The learned amicus curiae submits. What will be your submission?
But considering the length of detention and
Submit-
also
submit-
considering the fact that he's suffering from HIV.
He submits that considering the accused applicant's health as he being detected as HIV positive, as well as taking into account his long detention,
Also, one, my lord, non-compliance of section 47 and 40.
that will not record. There will be long detention inside the jail. At this stage, the court may consider him released on he may consider his release on bail. Full stop. This court has gone through the materials brought before this court, as well as the materials available in the TCR, which has been received by the court. Full stop. After hearing the learned counsel appearing for the respective parties and taking into account the facts that the accused applicant is suffering from HIV positive, as well as he's already spent 430 days behind the bars, and the fact that the victim girl, as well as the fact that the deposition of material witnesses, that is the victim girl, the informant, as well as the IO, have already been completed. This court is of the considered opinion that this is a case wherein the accused applicant could be granted bail at this stage. Full stop. Accordingly, it is directed that the accused applicant shall be released forthwith on bail on furnishing of a bail bond of rupees 20,000.
10,000, Your Lordship. They are belong from poor family. And
20,000 with a security of like nature to the satisfaction of the learned trial court, that is learned special judge, right? Learned special judge POCSO UPR, subject to the following conditions. You put those three conditions, POCSO thing. You can write one is that like he's not accused applicant shall not try to influence the victim girl and shall not try to go and contact. They're saying the same
now
house.
they are no more.
They were saying in the same house earlier.
No more, Your Lordship. After the release
The
of
accused applicant shall not try to go near the victim girl as well as the informant, in whatsoever manner. This thing, then the accused applicant shall be present before the trial court as and when called for. Then accused applicant shall not tamper or hamper with the investigation of the trial. And then you write, in view of the aforesaid directions, the instant bail application is disposed of as a law.
Martin.
Grateful.
Item number 9.
May I please, my lord? My lord, in this case, I'm not on the merits of the allegation. Similar grounds, my lord, non-compliance of 47 and 48.
Hmm.
The grounds of arrest which is required to be furnished to the accused person as well as the relative has not been furnished to me in this case.
What are the allegations here?
Allegations, my lord, section 75, subsection 2, sexual harassment,
Hmm.
punishment which goes up to 3 years. An outrage against the modesty of a woman, stalking, my lord,
Hmm.
and
So you
section
have been
2,
arrested when?
arrested on, my lord, 14/7/2025.
14/7/2025.
My lord, I have
And you are
been
behind the bars for how many days now?
162 days as of today, my lord.
162 days.
Yes, my lord.
80 days offense.
Yes, my lord.
Hmm. Then now what is the stage now?
Now, my lord, the trial has begun, my lord. It's in the
Trial has
stage of,
begun.
yes,
Trial
my
has
lord.
begun, and like what happened? I mean,
Stage of consideration of charges, my lord.
stage of consideration of charges.
Charges, my lord. If my lord may kindly have page number 27.
27, yes.
That is the arrest memo, my lord.
The signature of witness is not there.
No, my lord. Even the
No, no.
the grounds which they have mentioned, my lord. Those are the reasons of arrest, not the grounds of arrest.
But this is a arrest memo.
Yes, my lord.
But
And
what
there
is
was
about section 47 and 48?
no intimation has been furnished to us. No intimation of arrest. That is the reason, my lord, on the last occasion, this honorable court has called for the TCR.
Hmm. Have you gone through this?
Lordship, they have
47,
nowhere,
48 not served.
they have nowhere mentioned in their petition regarding the ground of arrest, Lordship.
Now he's taking it up. It's
No, I have mentioned, my lord. I have mentioned.
Lordship, moreover, Lordship, here, Lordship. On last occasion also, Lordship, they have not mentioned that ground of arrest is their Lordship. Because, Lordship, this is, Lordship, POCSO matter, Lordship. Only last occasion, Lordship, the victim party, they have to serve notice, Lordship.
Okay, victim is
Yes,
not
Lordship.
before this
Yes,
court.
Lordship.
We have the record shows that the notice has been served, my lord.
When was it served? I think very recently it was.
Yes, my
Yes,
lord.
Lordship. Yesterday,
This matter was,
received that they have been received, Lordship.
Okay,
Notice.
yesterday only.
Yes, Lordship.
my lord, in this matter was initially listed on 10/12/2025. And thereafter, we have served the notice,
See, this is a statutory mandate.
my lord.
I mean, victim or informant has to be heard.
My lord.
So
In
what
that
is to be
case,
done? I
my
mean,
lord-
we'll fix it sometime in the first week of
My
January.
lord may kindly appoint an amicus
No,
curiae.
that will do.
It's-
That will do.
And matter may
No,
kindly
that-
be,
no, I mean, see, it was received only yesterday.
my
So
lord.
we should give them some time also, isn't it?
Yes, Lordship.
And later on, they will come and say that we want a lawyer of our choice.
It's a matter of my lord, right, my lord. I've been under custody since last
It was
162
yesterday,
days, my
It's
lord.
a matter of their right also. It's a statutory right for them also.
My lord.
That they
Therefore, my
have to be
lord,
heard.
similarly,
And they have a right to engage their
My
own
lord.
lawyer. So it has been, I mean, it was received only yesterday.
yes, my lord. Similarly, in the same matter which was taken up,
No,
the earlier matter,
I mean, you were there.
my lord, may kindly appoint a
You-
amicus curiae and matter may kindly be fixed.
That's what I
Tomorrow.
say, this court is saying is that it was received only yesterday.
Yes, my lord.
So we should give them reasonable time
Time, my
to engage a lawyer. If
My
they
lord.
do not come up before the court, then we'll engage it. We will appoint an amicus. But that right has to be given them. We cannot take away that right.
Yes, true.
Correct?
That is the
So
reason.
we'll have to be considered, considered for them also. I mean, the victim is there.
That's true, my lord. But since
You
it's
have
not
a right to, you have a right to be considered for bail and they have a right to be heard.
otherwise, this is not a case of a penetration or anything, my lord. It's
No.
a case of section
But
12 of
there's
POCSO
a
Act.
mandate, there's a
Yes.
statutory mandate.
I understand that.
That is, I mean, victim has to be heard.
Heard.
So without that, it can't be done.
Otherwise, since this matter is pending since last 10/12/2025, it's been more than now 23 days, my lord. And
No, that's fine, but when did you file this? I mean, it is pending since when?
10/12/2025, my lord.
10, 12.
12, my lord. It's been more than now 13, 14 days.
14 days is
14
fine.
days.
I mean, for this kind of cases.
Otherwise,
I mean, where the victim has to be heard. 14 days, I don't think, I mean, I know that bail should be disposed of as early as possible. But thing is that when the victim is involved, it's not a normal other routine matter. It's a POCSO matter and the victim has to be heard.
Heard.
And we have seen this. I mean, it was received only yesterday.
Yesterday.
So we should give at least couple of days time. I mean, we don't know, then the victim will come and say that we want to engage our own lawyer. they have a right to choose their lawyer, isn't it?
That's true.
So we'll fix it first week of January, reopening. Right. The office heard Mr. So-and-so, the learned counsel appearing for the accused applicant, also heard MSL Hage, the learned APP for the state. The office note dated 22/12/2025 reveals not office note. I mean, you write something like this. A service report dated 22/12/2025 is found on record, which reveals that notice was received by the respondent number 2 only on 22/12/2025. In view of the aforesaid, let this matter be listed on
5th of January.
5th is holiday. 8th. Let the matter be listed on 8th of January. 8th of January. So if nobody appears, then we'll appoint an amicus, and accordingly matter will be listed within a short date.
Grateful.
Like Lordship, my supply.
Item number 5.
Item 6.
Paper book, name.
May it please your Lordship.
Yes, Mr.
At last, I get the opportunity. There are so many matters on the list.
Yes. Because this matter was part heard and fixed, so we are hearing it. I don't know about the other lawyers now.
Yes. Now,
What will happen to them? I don't
criminal
know.
matter. My criminal matters always will have to get priority. So your Lordship has therefore given
These are
priority
all-
to criminal matters.
Yes, those are bail
Yes.
matters. they
Liberty
inside the-
liberty of a person is involved.
Yes.
This is a revision against an order passed by the First Appellate Court in an injunction matter. My Lord, the two factions of a prestigious organization in Arunachal, my Lord, Arunachal Nishi Students Union, they have been litigating for quite some time. This is the 5th suit in line, my Lord. Earlier, there were 4 other suits. One has been returned and disposed of, therefore, and the rest are pending. So this is the 4th suit which is pending, and the order with which this Honorable Court and all of us are concerned was passed in the last suit, that is status suit number 21 of 2024.
Yes.
My Lord, the order, yes. My Lord, the order which has been challenged was passed by the First Appellate Court on 24/3/2025. And that being an order in a application under Order 39 Rule 1 and 2.
Yes.
My first submission will be the present revision petition is not maintainable in law. Lordship will kindly turn to page 197.
197 of the
Of the
Paper
paper
book.
book number 1, my Lord. There are, my Lord. I'll be arguing only on the basis of
Paper
paper book. Otherwise, it will be inconvenient for the court.
Yes, it will be difficult. Page 191.
197 is the first page of the revision petition. And my submission in this regard is that the present revision petition is not maintainable. Lordship will kindly see this is an application under section 115 of the Code of Civil Procedure. They have mentioned that read with 227, but this is the petition is under 115. My Lordship is aware, and my learned friend is also aware, that after the amendment of the Civil Procedure Code in 2002, the the revision against an order arising out of a petition under Order 39 Rule 1 and 2 or any other interlocutory or interim order is not maintainable. And for that matter, I am relying on small paragraph of the judgment of my Lord Surya Devi Rai, very famous case, your Lordship is aware of that, my Lord. For my submission only, I am referring to it. And my learned friend has given a book list. 2003, 6 SCC.
1 second. 2000?
2003, 6 SCC, page 675.
675.
And paragraph 4, I am relying, my lord.
Para 4.
My lord.
Kita pula agote boleh tu boleh. Book list dise no. Huh? Book list kita dise. Kita dise.
There was some delay possible. I'm just reading 3 lines where I'm reading very slowly. 3 lines where I'm reading very slowly. Paragraph 4.
Yes.
Section 115 of the Code of Civil Procedure as amended does not now permit a revision petition being filed against an order disposing of an appeal against the order of the trial court, whether confirming, reversing, or modifying the order of injunction granted by the trial court, like our case, my lord. The reason is that the order of the High Court passed either way would not have the effect of finally disposing of the suit or other proceedings. The exercise of revisional jurisdiction in such a case is taken away by the proviso inserted under subsection 1 of section 115. The amendment is based on the Malimat Committee's recommendations. The committee was of the opinion that the expression employed in section 115 CPC, which enables interference in revision on the ground that order is allowed to stand, would occasion a failure of justice or cause irreparable injury to the party against whom it was made, left open wide scope for the exercise of revisional power with all types of interlocutory orders, and this was substantially contributing towards delay in disposal of cases. The committee did not favor denuding the High Court of the power of revision, but strongly felt that power should be suitably curtailed. The effect of the erstwhile clause B of the proviso being deleted and a new proviso having been inserted is that the revisional jurisdiction in respect of an interlocutory order passed in trial court or other proceedings is substantially curtailed. A revisional jurisdiction cannot be exercised unless the requirement of proviso is satisfied. So this being the position, my first submission is that the present revision petition is not maintainable in law and that may be dismissed on that count alone. Now, I'll be arguing on merit. I'll be arguing on merit.
Yes.
And I have given my learned friend has in detail given the facts and submitted on facts. I will not repeat those submissions. I have given a 2-page list of dates. Lordship will kindly take those list of dates, ma'am. One is 2-page list of dates and another is 1-page note for the convenience of the Honorable Court, my lord.
Yes.
My lord, 2-page list of dates Lordship will find from serial number 1 to serial number 13 are the facts.
Yes.
Other side are the facts with which we are directly not concerned in this case, my lord. These are all past events.
Serial number 1 to?
Serial number 1 to 13, my lord.
13, yes.
The cause of action for the present matter has arisen from serial number 14, my lord.
Okay.
Just a few dates I'll read. Yes, my lord. Lordship will kindly take up this, my lord. Serial number 14, my lord, 2nd page, my lord. Ansu, my lord, answer your lordship, my lord has submitted that there are branch students union and delegates and contesting candidates are recommended by each branch who will ultimately contest election for the parent body, and each branch students union also will recommend delegates to be incorporated in the electoral roll who will cast their votes in the election of the parent body. Am I clear, my lord?
Yes.
parent body is Arunachal Nishi Students Union. And in this case, my lord, the two factions which are fighting are of one particular BSU, my lord, the Branch Students Union.
Yes.
And each of the factions, my lord, wanted to give a list of their candidates. One faction gave, plaintiffs faction gave 51 delegates' names, and defendants group gave 54 delegates' names. And there was an injunction. Well, let me read the list of it first, thereafter I'll make my submissions, my lord. So serial number
Otherwise,
14, my lord, Lordship.
How many delegates you can send? That is there in the constitution, right?
Well, no, there is no, I don't know, man, there is no specific name. But admittedly, in this case, my lord, plaintiffs delegates were 51 and defendants delegates were 54.
Then how come is there the variance is why this variance?
No, they themselves, plaintiffs themselves have given 51.
No, why this variance of numbers? I mean, there should be some fixed number, correct? If it is coming from the branch, then there should
My
be.
lord.
I mean, these are the numbers, fixed numbers. Then I mean, that can be sent from each
Absolutely,
of the branch,
my lord.
correct?
My
So,
lord, my lord,
is
my
there is there any number which has been?
My lord, it is not the plaintiff's case that we have been allowed to recommend less number of candidates. It is not their case, and it is not the subject matter of this case also, my lord. That has got no relevance in my humble submission. The issue is slightly different. I'm coming to that, my lord. Net issue. Even net. Net. No, bundles. Am I audible, my lord? Am I audible, my lord?
Yes, now audible and visible properly. No, what this court was asking basically is they just wanted to
I'm
know
sorry.
whether there is any specific number. Nothing about like whether it's relevant or not, but like court just wanted to know. That's what.
My lord.
Simple query.
My lord, I'm not. To be very frank, my lord, I've not seen that. I'll confirm.
Because like I think the constitution will be important in this matter. Maybe I'm not very sure.
May I assist, my lord?
Yes.
Because, my lord,
Constitution is there.
BSU, the delegates has to be collected from the schools of that particular branch.
How one school can send how many?
4 delegates.
Four
delegates.
And
those lists are there, my lord.
Correct. That's what I wanted to know. Is there
So
any?
they have sent. They have left out one school.
Okay.
So we have completed entire school, and that is the reason it comes to 54, and there it comes to 51.
Okay. So there is a list in the constitution which says how many delegates to be sent by one school.
From each school.
No, from each school, then the branch, the total number will be the branch number, right?
Correct, my lord.
Okay. Okay. Fine. Yes, Mr. Majumdar.
My
Carry on.
So, from list of dates, I'm again referring, my lord. From serial number 14, the story started, my lord. That was the date on which
We lost him again. You're not audible.
Notification for holding election for the parent board. So, am I not audible, my lord?
Yeah, sometimes it gets stuck. So, what you said, I could not hear you anything. And now you have to repeat it again.
My lord, I'm repeating.
Yes.
Till in the morning, it was okay. My lord. Anyway, serial number 14 is the date, my lord, 18/9/24. These are all admitted dates, my lord. I'm just giving the background. So, on 18/9/24, the election for the parent body was notified. And then, my lord, straightway, Lordship may kindly go to serial number 20.
Yes.
From here, the dispute started.
Yes.
Bikitania group urged before the election enrollment that.
We lost you again.
their names should only be registered as delegates, and 4 candidates. No. But am I audible?
No, we are missing you.
My lord. Then, my lord, serial number 20 is the very important. There I have mentioned Bikitania Group asked Election Enrollment Committee that their names should only be registered as delegates. And the 4 candidates and delegates recommended by Reitahia Group, that is the group in the defendant side, for contesting election should not be allowed. That was the initial thing, my lord.
Correct.
Then, my lord, yes. Then, my lord, serial number 22 and 23 are important. 9/11/24 notification about completion of enrollment process, enrollment of delegates of BSU could not be finalized and rendered, referred the issue to the CEC.
The connection gone again.
And 12/11/24 CEC approved the list of delegates. Possibly the Connect High Court has some difficulty. My one is okay, my lord.
Yeah. I mean, your link is missing in between.
Here it is all right, Lordship, because we are using Wi-Fi.
Hmm?
You are using Wi-Fi or High Court.
That's
Perfect.
fine.
It is perfect, Lordship.
There must be some problem here. Hmm? No, you have to put on
You are using High Court. It is perfect.
See, everyone is getting it, only the court is not getting it. I will just check.
Yes,
I'm
my
going to
lord,
clear
that
it.
is
I'm
the-
going to point it. We have subway pass.
Guest to you. Guest.
There's some problem here only.
Guest Wi-Fi. Yes, okay. No, guest Wi-Fi.
We are using the guest Wi-Fi. Lordship.
Oh,
It is
still you are getting it
very
properly.
Good.
And the parent is not getting it.
Oh. That may children are getting. My lord, serial number 24, Lordship may kindly see.
Yes.
Serial number 24 is the suit filed by them, my lord. There is a 4th suit in line. Title suit number 17 of 2024 filed by BK Daniel Party, challenging 9/11/24 order and CEC's order of 12/11/24, the above 2 orders, my lord.
Yes.
They have challenged, saying that the group which the plaintiff side did not like, their group's delegates were allowed, and the defendants group were not allowed. My lord, so far as defendant number 10, who is respondent number 1 before the lordship is concerned, and who has been elected as the president of the organization, my lord, as union.
Gone again.
Against him, there is absolutely no allegation in the case so far as respondent number 1, who was defected as the president and against whom the suit has been filed now. There is absolutely no allegation against him in the plaint. Then, my lord, on 14/11/2025, an injunction was passed in that title suit number 17 of 2024. My lord, in the present suit, they are alleging violation of that order. So thereafter, lordship will kindly see.
Yes.
Then that the court on serial number 26, my lord, 21/11. Court directed DC and SP to ensure compliance and enforcement to OC, etc. Then, my lord, serial number 28 is important. On 9/11/2024, election process concluded and the one was elected as the president. Result was declared.
Yes.
Then, my lord, they have filed an injunction violation serial number 29 and 30th serial number 30 is important, my lord. They have filed the fifth suit, that is the present suit, title suit number 21/24, where they have made certain prayer against the election of the respondent number 1, who was elected as the president, and then a temporary injunction was passed, which your lordship will find at page 38. They are elected president to function as the president. Lordship, the injunction was passed. Thereafter, an appeal was preferred, and on 28/1/2025, in the appeal, the order passed by the trial court, the temporary injunction that was passed by the trial court, has been set aside. On 24/3/2025, which your lordship will find. Appeal.
It was done by the civil court.
Yes, my lord. Yes, my lord. So the 28/1/2024 order is at the
So
178, my lord.
it was set aside on 24/3/2025, right?
My lord. The order dated 28/1/25 passed by the trial court was set aside.
Set aside, yes.
Against that, the present revision, yes, my lord. Against that, the present revision petition has been filed.
Yes.
So, my lord, that is the background of the case.
Yes.
Now, in a case, my lord, where the election of a returned candidate has been challenged, the question will arise whether by a temporary injunction, whether by a temporary injunction, the elected candidate can be
Not audible, Mr. Mazumdar, again.
restrained from functioning as somehow there is some, because it is possibly just slightly cloudy today.
Yes, I don't know when.
Basically, it is because it is slightly cloudy today in Guwahati, my lord.
No, maybe because of that.
So, my lord, my submission before lordship will be very simple. In a situation where a person has been duly elected by a body which is authorized under the constitution of the Students' Union to election, there is no allegation that the body has no power. So only allegation is during the election, there was earlier an injunction petition as far as the preparation of the insert. A temporary injunction can restricted candidate during the pendency of the suit, more so in a suit where the plaintiff is not praying that his election should be set aside and I should be declared elected. They are simply saying that you have to please hold a fresh election. They also don't want that they should be declared elected. He only wants that fresh election should be held. And in the election, who will win? So during the pendency of the suit, whether he is entitled to a temporary injunction to restrain the elected defendant number 10, respondent number 1 before your lordship. That is the whole issue, my lord. Now, in this case, as it has happened, trial court has granted a temporary injunction. Am I audible?
Yes, now it's coming up. Yes. Again, it's
Yeah.
gone.
Now, my lord, in this case, my lord, lordship kindly turns to the end, my lord, which your lordship will find at page 73 of the paper book, my lord. Page 73, my lord.
Yes.
My lordship will find that prayer number 1 is that the election number 10 should be declared as void. Prayer
Yes.
number 2 is that quashing the election result of 24, so number is concerned, so against him. And then next page, my lord, Roman.
We have lost you again.
Page 74. What page 74, my lord, they have made the next prayer for a decree for holding fresh election. I mean, extremely worried today because of suddenly this cloud, this connectivity disturbed.
Yes, I'm not following you only. There's a problem is that.
So, my sub.
It is difficult to follow you, Mr. Majumdar. We lost you again.
My lord. Yesterday the connectivity was very good, man. Today is
Yes, sometimes it's good. Today I don't know what has happened. What exactly has happened can't be said.
somehow there's some problem. No matter what, he should be declared elected. His prayer is that my election should be set aside and the authority should be directed to hold fresh election. That is the case.
Yes, correct. It was
Now, my lord,
it was only because of the injunction was there. I mean, in spite of the injunction, why
My
the
lord.
election happened? That was the case.
That is the case. Now, my lord, now I'll show 2-3 things, my lord. Lordship will kindly see page 63. What is the case of the whether the learned trial court was right in holding that the plaintiff has a privacy case or not? That I am showing, my lord. Lordship will kindly turn to page 63, my lord, para 34. That is the whole case. 34 and 38 are the grounds in the main case, my lord. Page 63, para 34,
no,
my lord.
14, Mr. Majumdar, 1411 was challenged, right? 1411 injunction order that was challenged.
No.
My
That was
lord.
challenged.
No
It was not challenged. There is still
My
there
lord,
is still there.
my lord, for the sake of a lordship is my lord,
No, right now, no, Mr. Majumdar, rightly or wrongly, order
My
has
lord,
been passed by judicial court.
my submission is for 1 minute. 14/11/24 order is still valid and time in terms of the 14 was not prepared. The plaintiff is not entitled to any temporary injunction. That is my submission, my lord. Why I am, my lord, submitting, my lord. In spite of assuming but not admitting that 14/11/24 injunction was not complied with, even then the plaintiff has not been able to make out a prima facie case for grant of temporary injunction. That is my submission, my lord.
No, we lost you again. I mean, this will be difficult this way, Mr. Majumdar.
My lord, no, I'm just waiting for your lordship. I'm just waiting for your lordship to take the note, otherwise
No, you stop. I mean,
I'm continuing.
your thing has gone. Again, it has gone.
My lord, para 34, I'm reading, lordship kindly bear with me, madam. Para 34.
Yes.
Para 34 at page 63, I'm reading my one paragraph, your lordship will kindly permit me to read, madam.
Yes.
Be that as it may, as per the records, there were 5 contestants for the post of president and one Sri Swen, so there is different number 10, my lord. Securing 2,322 votes has been declared elected, while Ashok Doka, the plaintiff number 1, has secured 2,231 votes and has been defeated by a margin of 91 votes only. It is pertinent to state that out of 91 votes, 54 votes of the delegates of the rival party are illegal, as they were prohibited from participating in the election process by this honorable court, and they are supporters of Legend Gyadi, who was also fully supported by defendants. Had the petitioners and their delegates been allowed to vote in the election as directed by the honorable court, in place of delegates of rival party, the election result would have tilted in favor of the presidential candidate, and Ashok Doka would have been elected as the president of ANSU in place of Legend Gyadi by the margin of 14 votes. Therefore, for non-complying of the order of honorable court, plaintiff right to elect their choice of presidential candidate has been infringed, and entire election process with regard to the election electoral central executive members, where there is a margin of 108 votes, is vitiated with illegality and untenable in law and is liable to be interfered with, etc., etc. My lord, my submission is this is allegation number 1 in the plaint, that there was an order and their delegates were not allowed to participate. Now, lordship kindly see para 38. What are the main grounds on which the suit was filed seeking a decree that my election should be set aside? Para 38 at page 66, my lord. I will not read the whole paragraph, only the relevant portion, my lord. Towards the end of the paragraph 38 at page 66, my lord, before those Roman 1 and 2, the sentence says, in the ground report, they have brought out various anomalies and illegalities, which are as follows. So these are 1, 2, 3, 4 grounds on which they have filed the suit. 1, election volunteers were allowed to openly distribute money inside the election hall at the time of voting by the respondents' contemners, number 1. Number 2, many proxy voters sponsored by election volunteers were facilitated through secret route inside the election hall and allowed to cast votes by the respondent contemners. And the genuine voters were denied voting rights. And lastly, my lord, the violation of that injunction, the respondent contemners openly defied the orders dated 14/11/24 and 21/11/24 passed by the judge earlier in the earlier suit. So these are the 4 grounds on which they have filed the suit. Now, so far as the ground number 1, 2, my lord, there is a Roman 4 also, last ground, my lord, without election committee, without counting the votes, has declared the result of post of vice president and proceeded. So far as the present petitioner is concerned, respondent was concerned, my lord, there are 3 grounds: that openly distributing money inside the election hall, proxy voters allowed to cast the votes, and violation of order of injunction. On these 3 grounds, the suit was filed. Learned trial court, my lord.
Yes.
May I continue, my lord?
Yes, please.
Learned trial court only considered the violation of injunction. Other 2 grounds, learned trial court did not discuss. That is my first submission, my lord.
Which are the grounds not discussed?
1. Page 66, my lord, there are 4 grounds.
Correct.
And the present present defendant is concerned with ground number 1, 2, and 3 because he was elected as president. Out of these 3, only 1 ground, that is violation of order dated 14/11/24 was discussed to form an opinion
Ground number 3 was
that
discussed.
the plaintiff. Only ground number 3 was discussed, 1 and 2 were not discussed. That is my first submission on which the trial court's order cannot stand. Because for forming an opinion that there is prima facie case, trial court has to discuss all the points raised by the plaintiff. And now I'll show, my lord, because of violation, if any, of order dated 14/11/24, the plaintiff cannot make out a prima facie case, and there is a direct judgment of our, of our Dibrugarh matter, my lord, went to Supreme Court. I'll come to that. That, my lord, there is a presumption that if 51 delegates sought to be recommended by them, if allowed to cast their votes, will cast votes in favor of the plaintiff number 1. Where is the, my lord, guarantee? This is what the Supreme Court has said in the case of Kalyan Kumar Gogoi's case, my lord. I'll refer to that immediately, my
Yes,
lord.
Mr. Majumdar, I'll just interrupt. Just for my clarity, there are
My
four
lord.
grounds, right?
My lord.
If a judicial forum, after reading one
My lord.
ground only, comes to a
My
conclusion,
lord.
then there should be a mandatory. There should be an injunction. Whether that can't be done without discussing the other three.
That can be done, but here I am showing, my lord, so far as the ground which was taken into consideration by the trial court is concerned.
So then your argument
lord.
saying that though
My
there
lord.
were four grounds, only one
My
ground was discussed and like three grounds were not discussed while
My
giving the temporary injunction, correct?
My lord.
So
My lord.
no, what this court is asking basically whether
Yes, my
a
lord.
judicial forum cannot take this view. Reading one ground only. If
My lord, I'm
one
responding.
ground one ground itself is sufficient to take come to that conclusion.
Lordship is absolutely correct. But here I am showing, my lord, that is my second point, that even if there
Yes.
has been a violation of third ground, that is violation of
Yes.
order rated 1411/24, there is no question of any prima facie case, my lord. That I'll show, my lord. That is why
Okay.
I'm saying that is my submission, my lord.
Okay.
That is my submission, because ground number 3 will fall only on the basis of one judgment I'll show, my lord, of Kalyan Kumar Gogoi, where the Honorable
Correct.
Supreme Court has said, my lord, that only because some voters could not cast their votes, you cannot count that those votes, if cast, would have gone in my favor. Similarly, my lord, so far as those 54 votes are concerned, the allegation in the plaint is these 54 persons who were illegally allowed to cast their votes, there is a presumption, my lord, though not properly pleaded, that all those 54 votes have been cast in favor of defendant number 10. No, you are not saying in the plaint that all these 54 persons have cast, because there were 5 candidates, my lord. Election result I'll show, my lord. There were 5 candidates who have, all of them have got votes, more than 100. So where is the presumption that, because it is a secret ballot, you are presuming, plaintiff is presuming that 54 votes who were illegally allowed to cast their votes have actually cast votes in favor of defendant number 10. And I am repeating this submission because my whole case is based on this argument and the judgment on which I am relying so far as this point is concerned, my lord. There is no presumption. Yes, at the end of the trial, my lord, if they can bring sufficient evidence, provided there is sufficient pleading to that effect. Well, there is a judgment of the Honorable Supreme Court which says that if there is no pleading, you cannot bring any evidence. No amount of evidence can be looked into if there is no pleading. Here, my lord, there is no pleading that all those 54 persons who were illegally allowed to cast their votes, they cast their votes in favor of the defendant number 10. That allegation is not there in the plaint, my lord. They are saying that if they were prevented, I would have won. But where is the pleading that they have cast their votes, and where is the material to come to a privacy view that yes, these persons have voted in favor of defendant number 10. They might have voted for some other person. So that is my submission with regard to 1411/24. Even if, assuming for the sake of argument, my lord, that 1411/24 was violated, even then you have got no case. You are not entitled to any injunction at this stage. Because, my lord, there is a reason. There is a reason it's like this, my lord. There is one judgment which I'll just now show, my lord. My lord, today the trial court, that is the civil court, passes an order of temporary injunction in favor of the plaintiff. And tomorrow, the suit is decided after 6 months or maybe 1 year. And if the suit is dismissed, what happens, my lord? The defendant number 10 who was elected has been deprived of your right to act and function as a president for 6 months. Well, that is why the Supreme Court says there is a risk of the court being wrong at the end of the trial. So if the temporary injunction is granted today, and after 6 months, my learned friend did not speak from there because I am being disturbed by this discussion between the two lawyers there, man. What I am submitting is, my lord, if today there is a risk, Supreme Court says, my lord, there is a risk that the court may ultimately become wrong, because if today temporary injunction is granted, after 6 months or 1 year, if the suit is dismissed and the court is found to be wrong in granting the temporary injunction, there is a risk of being wrong. Similarly, my lord,
that risk is there. But thing is that in this case already that the injunction was given.
My lord, that is why I am saying merely because the injunction is given, they are not entitled to injunction, my lord, temporary injunction. Even if there is a violation of
Entitlement, dissettlement, that will come later on. But when the injunction is given, whether you can flout it, whether it can
No,
be
I am not
flouted.
saying, my lord. My lord, I am rather accepting that if the injunction is violated, even then they are not entitled to temporary injunction. My submission is not that I have a right to violate that order passed by the court. Absolutely not, my lord. That is not my submission. My submission is otherwise. My submission is, even if there has been a violation of temporary injunction of 14/11/24, even then they are not entitled to injunction. And why, my lord? For that I am making my submission. My lord, this is one aspect, that if the temporary injunction is granted. Now, if the temporary injunction is not granted today, and ultimately at the end of the trial, my lord, if the suit is decreed, then also there is a risk, my lord, of being ultimately wrong. Am I clear, my lord?
Yes.
Ultimately, if the suit is decreed and today injunction is not granted, then the court is going to be wrong that, interim injunction was not granted. Now the Supreme Court says, where the risk is more, whether the risk is more in granting temporary injunction and preventing a person who is elected, and after 6 months, even if the suit is dismissed, he is not going to get back the period of 6 months during which he has been deprived his right to function. Whereas, if there is no interim injunction today and ultimately suit is decreed, a fresh election will be held. In the fresh election, the plaintiff may not get elected. Plaintiff is not sure to be elected even if the ultimate suit is decreed, because his prayer is that direction to hold fresh election. In the fresh election, who will come, who will vote, who will win, nobody knows today, my lord. So the risk is less there in refusing injunction. That is my submission, my lord. And on that point, my lord, I will cite a judgment. This is my argument, lordship will kindly take note, my lord.
Yes.
Yes. So, my lord, I am saying that he has got no prima facie case because based on para 34, my learned friend was arguing yesterday that they have given numbers. They are arguing 51 votes, 54. I am not arguing. It is plaintiff's case that their delegates were 51, opponent party's delegates were 54, and opponent party were allowed to cast their votes. Plaintiff's party were not allowed to cast their votes. And that is why this margin. Now, my lord, lordship will kindly see what they have done in the next page, that is page 64. They have won the election by a margin of 14 votes. Had the temporary injunction passed in the earlier suit been followed, they have given this number. It's not my number. Page 64, they say that if their recommendations were accepted, then they would have won by 14 votes. And this is because, my lord, what they have done, there is a margin of 91 votes by which the defendant has won. From 91, they have deducted first 54 votes, assuming that all these 54 delegates of the other group, not the group of defendant number 10, my lord. Defendant number 10 has got no role here. There is no allegation against defendant number 10. He is an independent candidate. He contested the election and he has won the election. There is no allegation against him. Allegation is made by one group against the other group. And what they have done, from their 91 votes by a margin of which the defendant number 10 has won the election, from there they have deducted first 54 votes. it comes to 37. Then from there, what they have done, their delegates were 51. So from 51, they have deducted 37 to come to the figure of 14, saying that if all those persons who their group has recommended, if they were allowed to cast their votes, they are presuming that all those persons would have actually cast on the date of poll in favor of plaintiff.
him.
On
yes.
this presumption, they have made the calculation, and they are saying that they would have won the election by a margin of 14 votes. On this basis, they are saying that they have got a prima facie case. My submission before your lordship is, on the basis of the allegations made in para 34, so far as para 38 is concerned, there the other two grounds have the court have not discussed. So I am only saying that those points have got nothing to do with the present injunction order. They have to seek validity of the trial court's order only on the basis of the order allegations made in para 34 that there was an injunction not to allow the one group and to allow the other group, which was not done. So they are saying that if that order of 24/11/24 was complied with, we would have won the election. On the presumption, I am repeating the submission, my lord, this is my case, on the presumption that all those persons of their group would have actually gone to cast their votes and would have actually cast their votes in favor of plaintiff number 1. In my humble submission, my lord, there is no presumption in law or fact. Yes, at the end of the trial, after the suit is finally decreed after recording evidence, if it is found that yes, all those persons have come to the court and said that yes, I cast the votes in favor of defendant number 10. And this way, if it is found out in the evidence at the end of the trial that 54 persons of this group, if their ballot papers are taken out, they have actually cast their votes in favor of defendant number 10, then their votes will be deducted 100%. And so far as these 51 persons belonging to their group is concerned, they must come to the court, and if they come and depose, saying that yes, all of us, if allowed to cast, will cast vote in favor of plaintiff number 1. Then the matter will be different. That is the end of the trial. That is why I am saying, my lord. At the end of the trial, who will get the decree? Nobody knows today, because evidence is yet to be recorded. But today, we have to proceed on the basis of the allegations made in the plaint and find out whether there is a prima facie case. Now, my submission is on the presumption. They are saying that they have got a prima facie case. My submission is there is no presumption in law or fact that if these persons are allowed to cast their vote, they will cast their vote in favor of the plaintiff. And that is why, my lord, there is no prima facie case, because with these allegations in an election matter, my lord, without specific pleading that these 54 persons have actually cast their votes in favor of the defendant number 10, they cannot lead any evidence also. Supreme Court is very clear on that. So with these pleadings, you cannot say that you are ultimately going to get the decree. And unless this court prima facie forms an opinion that on the basis of this pleading, let us assume that they can bring evidence. On the basis of the pleading, they are not going to get a decree, then they don't have a prima facie case. This is what the one judgment is there, I have brought on that. This is what the law is.
So against you, there is no allegations?
Against me, there is no allegation, my lord. And I am an independent. I have contested the election. I have won the election. And now these two groups are fighting, and the plaintiff number 1 belonging to one group, my lord, his allegation in the complaint, etc., was there that his delegates who will ultimately contest the election. There are two things, my lord. One is list of delegates who will contest the election, and a list of delegates who will cast their vote. So far as contesting candidates are concerned, his allegations were there that his group's contestants were also not allowed to participate in the election, but he was allowed. Plaintiff number 1 was allowed to contest the election. So that allegation he doesn't have about not allowing the contestants to contest the election. So this is the case, my lord. Now, lordship will have to decide whether, and there is one more thing, my lord. Since the learned trial court has granted the temporary injunction only on the ground that there has been a violation of 14/11/24 injunction order passed earlier in title number 17 of 24, the first appellate court was of the view that, see, you have filed an application alleging violation of injunction, and that petition is yet pending. Now, presently, that petition has also been heard. Judgment is reserved by the trial court. That application is pending. The first appellate court has come to a finding that when the injunction violation petition you have filed and that is pending, on the assumption that injunction was violated, trial court has passed an order, how could it be predetermined? It will amount to predetermining the issue itself. Injunction violation petition is yet to be decided. A decision is yet to be taken as to whether the injunction was violated or not. The trial court has held that it was violated, but petition is still pending. And that is how the first appellate court has set aside the order passed by the trial court, saying that no, that petition is still pending. How can you predetermine the issue that injunction is still violated? You have filed an application alleging violation of injunction and for imposing a penalty. As
Where
per
is
order
that, where is
39 rule.
that one?
My lord,
Where was the order? Which was the order?
violated, my lord, 1411, my lord.
1411 only. Yes, yes, yes. Yes, correct.
Injunction order was 1411/24. After that, they have filed an application for injunction violation that is pending, my lord.
That is still pending. Then
My lord, that is, I have given in my list of dates serial number 29, my lord.
Yeah.
Miss case number 39 of 24. Hearing is concluded. The court is yet to pass an order.
On fourth hearing, it was concluded, my lord. On fourth. It is under order 39 rule 2A.
Judgment.
the 39 of 2024.
39
My
rule
lord.
2A, they filed it.
Madam, may I now possibly I have made my point. May I cite those judgments, my lord?
Yes, yes.
My lord.
Yes.
First is my lord. 1992 1 SSC page 719.
1 second.
My lord.
1992.
1992 volume 1 SCC 1 SCC, my lord. 719. Your lordship is aware that Dalpat Kumar's judgment, my lord.
Okay.
719. Para 4 and 5. 4 and 5, my lord.
Yes.
Small paragraphs, my lord, I am reading, my lord. Lordship will kindly straightway turn to page 720, my lord.
Yes.
Para 4 at page 720, my lord.
Yes.
My lord, from the bottom, maybe 6th line from bottom, right hand side, injunction is. Injunction is, lordship has got, my lord. Injunction is a judicial process by which a party is required to do or to refrain from doing any particular act. It is in the nature of a preventive relief to a litigant to prevent future possible injury. In other words, the court on exercise of the power of granting ad interim injunction is to preserve the subject matter of the suit in the status quo for the time being. It is settled law that grant of injunction is a discretionary relief. The exercise thereof is subject to the court satisfying that there is a serious disputed question to be tried in the suit and that an act on the facts before the court, there is probability of his being entitled to the relief. There should be a probability that he will ultimately be entitled to the relief asked for by the plaintiff defendant. The court's interference is necessary to protect the party from the species of injury. In other words, irreparable injury or damage would ensue before legal right would be established at trial, and that the comparative hardship or mischief or inconvenience which is likely to occur from withholding the injunction will be greater than that would be likely to arise from granting it. Para 5, my lord. Therefore, the burden is on the plaintiff by evidence alienate by affidavit or otherwise that there is prima facie case in his favor which needs adjudication at the trial. The existence of the prima facie right and infraction of the enjoyment of his property or the right is a condition for the grant of temporary injunction. Prima facie case is not to be confused with the prima facie title which has to be established on the evidence at the trial. Only prima facie case is a substantial question raised, bona fide which needs investigation and a decision on merits. Satisfaction that there is prima facie case by itself is not sufficient to grant injunction. The court further has to satisfy that non-interference by the court would result in irreparable injury to the party seeking relief, and that there is no other remedy available to the party except one to grant injunction, and he needs protection from the consequences of apprehended injury or disposition. Irreparable injury, however, does not mean that there must be no physical possibility of repairing the injury, but means only that injury must be of a material one, namely one that cannot be adequately compensated by way of damages. The third condition also is that the balance of convenience must be in favor of the granting injunction. The court, while granting or refusing to grant injunction, should exercise sound judicial discretion to find the amount of substantial mischief or injury which is likely to be caused to the parties if the injunction is refused, and compare it with that which is likely to be caused to the other side if the injunction is granted. If on weighing the competing possibilities or probabilities of likelihood of injury, and if the court considers that pending the suit, subject matter should be maintained in status quo and injunction would be issued, thus the court has to exercise its sound judicial discretion in granting or refusing the relief of ad interim injunction pending the suit. So Lordship has seen, my Lord, the Honorable Supreme Court is saying that it is to be preserved. I have been elected, whether the Honorable Court will preserve my status position and maintain the status quo, or your Lordship will disturb my position and ask him to come today. And if tomorrow if the suit is dismissed, then I have been deprived of my right, which cannot be compensated in terms of money. That is my submission in support with the help of this judgment, my Lord. Yes, at the end of the trial, if he wins, the matter is different. But today, Lordship will have to decide which way we'll have to weigh, my Lord, which way the tilt is there, my Lord. So, my Lord, my second judgment which I am referring to is 2025 Supreme Online Andhra Pradesh, this is Andhra Pradesh High Court judgment, my Lord. My learned friend will give a copy. 2025 Supreme.
Yes.
Within bracket online, and then within bracket Andhra Pradesh AP 6783 Sheikh Dada Mia versus S. Jiaur Rahman.
6783.
My Lord, para 17, only one paragraph I'm relying, my Lord, para 17. Lord, will kindly see page 6, my Lord, right hand side, bottom the pages are there. In this judgment, Dalpat judgment also it is mentioned. I'm just referring, it's better words are better, my Lord. Para 17, my Lord.
Yes.
Prima facie case means that there is a serious disputed question to be tried in the suit, and that an act on the facts before the court, that the probability of the plaintiff being entitled to the relief asked for. Same thing, my Lord. Same thing. So what I'm saying is prima facie case doesn't mean that you say that there was a violation of injunction, so kindly grant me temporary injunction. No. You should be able to establish prima facie before the honorable court that ultimately in the trial, my suit is going to be decreed because I have said that 54 persons who were illegally allowed to cast their votes actually cast their votes in my favor. There is nothing today, my Lord, before this honorable court. They have cast 2 votes in favor of him, 3 votes in favor of one candidate, 5 votes in favor of another candidate. We don't know, my Lord. Nobody knows. There is evidence is yet to be recorded. Where is the presumption, my Lord? I fail to understand where from the presumption is there that all those 54 votes were actually cast in favor of plaintiff defendant number 10. Neither there is any allegation nor there is any material, because in the absence of any allegation, my Lord, they cannot bring any evidence also. That is only a matter of evidence, my Lord. I'm not urging before Lordship, not troubling this honorable court with that, my Lord. So that is the judgment, my Lord. Then next is, my Lord, 2023.
Yes.
SCC online. Then SC, Supreme Court, page 177, my Lord.
Para?
Para 73, my Lord.
Yes.
Para 73, my Lord. In fact, in para 73, Reliance has been placed on another case of 2021 SCC online. May I read, my lord?
Yes, one second. Yes.
Yes. So, my lord, apart from the above, para 73, my lord, apart from the above, we may also take note of the principles in relation to the matters concerning grant of interim relief, which have been stated and re-emphasized by the court in case of so and so and so, para 194 thereof. In addition to the general principles for exercise of discretion as discussed therein, a few features specific to the matters of interim relief need special mention. It is rather elementary that in the matters of grant of interim relief, satisfaction of the court only about existence of prima facie case in favor of suitor is not enough. The other elements, that is the balance of convenience and likelihood of irreparable injury, are not of empty formality and carry their own relevance. And while exercising its discretion in the matter of interim relief and adopting a particular course, the court needs to weigh the risk of injustice. This is what I was saying, my lord. If ultimately the decision of the main matter runs counter to the course being adopted at the time of granting or refusing the interim relief, we may usefully refer to the relevant principles stated in the decision of Chancery Division in so and so, reported in All England Reporter, my lord. The principal dilemma about the grant of interlocutory injunctions, whether prohibitory or mandatory, is that there is by definition a risk that the court may make the wrong decision. In the sense of granting an injunction to a party who fails to establish his right at the trial, or would fail if there was a trial, or alternatively, in failing to grant an injunction to a party who succeeds or would succeed at the trial. A fundamental principle is therefore that the court should take whichever course appears to be the lower risk of injustice if it should turn out to have been wrong. In this sense, I have described the guidelines for the grant of both kinds of interlocutory injunctions are derived from this principle. That's all, my lord. So, Lordship, this is what I was submitting, my lord, with my lord, all humility, that there is a risk that the court may ultimately prove to be wrong because initially injunction was granted, but later the suit is dismissed. Then there is a factor that initially injunction is not granted and ultimately suit is decreed. No, Lordship has to weigh that by which course of action your Lordship, the Honorable Court will be running less risk. So, my submission is, today if the injunction is refused, then there will be a fresh election and he may or may not be elected. So, the risk is not very high. But on the contrary, if the injunction is granted today and ultimately suit is dismissed, then, my lord, risk will be high of being wrong because a person who was duly elected has been deprived of his right to function as such, but at the end of the trial, now the suit is dismissed, so he has to get back his office. So therefore, my lord, my submission before Lordship is, and particularly, my lord, the trial court has not discussed the other two factors, irreparable loss and injury, and straight to a privacy case, and just a few words mentioned, but this risk factor, etc., as I am submitting, these things were not at all discussed as to where the court is running a risk of being wrong ultimately, where the risk is higher. Am I clear, my lord? My lord, that is my submission. Then, my lord, the next judgment I am showing is the 2011 2 SCC page 532.
2011?
2 SCC.
2 SCC?
Page 532.
32.
My lord, this is Kalyan Kumar Gogoi, it's a Supreme Court judgment and it went from our High Court, my lord. In an election matter, paragraph, my lord, 5, 6,
yes,
47, 48, and 49.
Yes.
In a similar situation, what has happened, my lord, will kindly see. Para 5, my lord. The appellant claims that his election agent lodged a complaint before the Deputy Commissioner Dibrugarh, who was also the returning officer for the constituency concerned, and therefore polling station was shifted to the notified school and was made functional later on. It is necessary to mention that out of the total 1050 votes whose names were registered as the polling station located at the school notified, 557 voters had cast their votes, which constitute, according to the appellant, 53.8% of votes, while the total polling percentage in the entire constituency was 67.23%. The counting of votes for the election of the state constituency took place on so-and-so, elected having been so-and-so, as the appellant could secure so-and-so votes out of the total value votes of so-and-so. Thus, the margin of votes between the appellant and respondent was about 175 votes. Lord should kindly see. Now, para 6. On the same day, appellant lodged a complaint before the returning officer demanding a repoll on the polling station concerned, inter alia making a grievance that shifting of the polling station from the notified area to so-and-so railway colony LP school was illegal and deprived many voters from exercising their right of franchise due to utter confusion and chaos. Similar is the allegation, my lord, in our case, that because of illegal preparation of electoral roll, some voters were not allowed to cast their votes. Now, lord, will kindly see paragraph 47, my lord.
Yes.
My lord, <clears throat> 47. I'll not read the entire paragraph, my lord. My lord, I have to read. Para 47, my lord. It is common knowledge that voting and abstention from voting, as also the pattern of voting, depend upon complex and variety of factors which may defy reasoning and logic. Depending on a particular combination of contesting candidates and the political party fielding them, the same set of voters may cast their votes in a particular way and may respond differently on a change in such combination. Voters, it is said, have a short-lived memory and not an inflexible allegiance to political parties and candidates. Election manifestos of political parties and candidates in a given election, recent happenings, incidents and speeches delivered before the time of voting may persuade the voters to change their mind and decision to vote for a particular party or candidate, giving up their previous commitment or belief. Para 48. In so-and-so, this court has taken judicial notice of the fact that in India, all the voters do not always go to the polls, and that the casting of votes at an election depends upon a variety of factors, and it is not possible for anyone to predicate how many or which proportion of votes will go to one or the other of the candidates. Therefore, 200 to 300 voters not casting their votes can hardly be attributed to change of venue of the polling station, though evidence on record does not indicate at all that 200 to 300 voters had gone back. This is the facts of the case, matter. Then para 49 is important. Even if it is assumed, for the sake of argument, that about 200 to 300 voters had gone away without casting their votes on learning that no polling station was set up at the notified place, this court finds that no evidence relating to the pattern of voting, as was disclosed in the various polling booths at which the voters had in fact gone, was adduced by the plaintiff, as was adduced in so-and-so, on the basis of which the law of averages was arrived at against the election petitioner therein. Therefore, it is very difficult to accept the ipse dixit of the appellant and his witnesses that if 200 to 300 voters had gone away without casting their votes due to non-setting up of a notified polling station, they would have voted in favor of the appellant. There is no warrant for drawing presumption that those who had gone away without casting votes would have cast their votes in favor of the appellant if there had been no change of venue of voting. Vashit Narayan's case insists on proof. Well, there is an earlier judgment of 1954 Supreme Court, Vashit Narayan. There, my lord, in fact, judgment has been relied on this case. There, a detailed discussion has been made that, yes, on proof, you can, at the end of the trial, if you can establish your case, then matter is different. Today, my lord, prime as a court has to determine on the basis of the pleadings, Jot. On the pleadings. Now, pleadings, my lord, absolutely silent that all those persons, if allowed to cast their votes, would have cast their votes. They are presuming that they were not allowed, so I have lost. Those persons illegally allowed, so I have lost. These are all presumptions. Specific pleadings are not there, and evidence is yet to be led. Today, your lordship has to decide whether who is entitled to an interim injunction. And my lord, interestingly, in this case, the Honorable Supreme Court, as your lordship has seen just now, has said that people have short memory, number one, and number two, they change side. And in this case, my lord, this has happened. This has happened. A group which was earlier supporting the other side, my lord.
Yes.
Excuse me, my lord.
Yes,
Other
yes.
side, they have, during the pendency of the litigation, they have changed side and they have filed an affidavit admitting the allegations made by the plaintiff so that the plaintiff gets a decree. So this thing has already happened in this case. My learned friend has argued, I am also accepting, my lord. There is admission. Written statement was earlier filed denying all the allegations by some of the defendants. Subsequently, my lord, there is a change in the mind. They have filed, my lord, additional affidavit admitting everything in the plaint. One group has already gone. This has already happened. Honorable Supreme Court is absolutely right. And in this case also it has happened. In this background, my lord, lordship has to decide whether the injunction should be granted or not. And the other, first of all, my lord, with these pleadings, my humble submission is prima facie case is not made out. Even if it is made out, the other two factors will highly tilt in favor of the person who has been elected, because he is already elected. There is a high risk of being ultimately wrong. And my lord, in this case itself, in this Kalyan Kumar Gogoi judgment, para 28, if your lordship goes, my lord, it was a case of MLA. So it is governed para 28 and 30, my lord. My lord, lordship is aware in an election matter which is governed by the Representation of People Act, there is a provision section 101D, which says, my lord, if a person alleges corrupt practice, then the matter is different against the candidate. But if a person is filing a case for non-compliance of the rules and procedures, like in our case, my lord, there is a constitution. Constitution provides that there will be an enrollment list, and there is a allegation that has been violated, and that is why there is a prayer that election should be set aside. In such a case, my lord, Honorable Supreme Court mandates that in the ultimate trial, you should be able to show that the election of the returned candidate is materially affected. Reason is very simple, my lord. Today, a person wins an election by a margin of 500 votes. I'm sorry, my lord. In the trial, my lord, if it is found that 10 persons have actually illegally voted and their votes are to be excluded from the list of validly cast votes, will it change the result of the election, my lord? No, because it is not materially affecting the result of the election. Margin is 100 or 500, and the illegal votes are found to be 10 or 15. That is not going to change the fate of the returned candidate. And that is why the Supreme Court, my lord, even in this case, there are other cases, I have not troubled your lordship with those cases, your lordship is aware of that unless you are able to show in a case of violation of the rules and procedures and statutes and order passed by the Election Commission, that because of that, there has been a materially affecting the result of the returned candidate, you are not going to get any relief, merely because some illegalities have taken place. Similar is the case here, my lord. Assuming for the time being that injunction of 14/11/24, which was allegedly violated, it was violated, assuming that, you have no case. Because then there is a difference of only 51 persons or 54 persons, either way, my lord, provided in the end of the trial, you are able to show that all those 54 persons who were illegally allowed to cast their votes had actually cast their votes in favor of the returned candidate. There is no material absolutely, my lord, before your lordship today, my lord. That is my humble submission. So far as 51 persons sought to be recommended by them for casting votes are concerned, there is no material, there is no pleading that these persons had actually gone and cast their votes. These persons have actually, my lord, cast their votes in favor of the return candidate, 54 votes, return candidate. There is no material, my lord, today. So lordship has to decide in these circumstances. My lord, one thing I would like to show here.
Yes.
My lord, one thing I would like to show, if your lordship kindly goes to the, my lord, paper book once, my lord.
Yes.
Paper book 1. I'm sorry, my lord. In the paper book, my lord, your lordship kindly turns to page 325. 18.9.
It will be in paper book number 2.
My lord, it is paper, yes, number 2. 325, 18.9.
Motivation.
Itu two license. Liquis dulu. Or itu pasal. 325, my lord. 18.9.
Yes.
325, my lord, is the part of the Constitution, Article 21, my lord.
Yes, elections.
Yes, elections. There shall be a single election commission to superintend, direct, and control all election process of the General Conference and elect central executive body members. So they appoint, my lord, very formal. They are very formal. They are very advanced, my lord. As students in an organization, they are having such a beautiful constitution. They are saying that there will be an election commission, and that election commission will elect. And then Article 21, sub-article 1, what shall you kindly see? The president shall constitute the election commission consisting of chief election commissioner, returning officer, presiding officer, etc., etc. Now, in our case, my lord, by an order of 18/9/24, I have given in my list of dates, my lord.
Serial number 14, man.
Yes.
My lord, there is an order of 18/9/24.
The election
My lord,
notification.
my lord, election notification. And election notification says, my lord, and whereas Article 20, sub-article 2 of the president shall appoint chairman, etc. Next paragraph says, now therefore, while exercising the power vested upon the President Ansu of Union Constitution, I, Sri Swenso, do hereby appoint the Election Enrollment Committee for etc., etc., etc. So it is the election held by an order passed by the President, appointing the Election Commission, appointing the Election Commission, and thereafter the election was held. So far as the power to hold election is concerned, there is absolutely no dispute. Only thing is they are saying that in the election, some of the voters, according to their choice, were not allowed to cast their votes. Some of the voters who were not to be allowed by the order of injunction, they were allowed to cast their votes. This is the only allegation, my lord. And the trial is yet to take place. Today, the prayer is that injunction should be granted to prevent the elected person when in the entire plain there is no allegation against the elected person, that is defense number 10, which is response number 1 before lordship, that he has done this illegality or that illegality. The fight is between two groups. And so far as plaintiff is concerned, lordship will find there are 3 plaintiffs. Whereas plaintiff number 1 has only contested the election, my lord.
Yes, let's see.
So in between, there are fight going on between two groups, and defendant number 10, who has been elected, is to lose the right to function as president after he has been elected. The voters have gone there, cast their votes, my lord. And you made allegation that there were proxy votes, there was these allegations, that allegation. Learned trial court, if your lordship goes to the order, my lord, has come to form an opinion, lordship. I'll just show one thing, my lord, from the order passed by the learned trial court. If your lordship kindly goes to page 193, my lord. Order of the trial court 28/125, my lord. Lordship will kindly turn to page 194. Parties' submissions have been recorded. And page 194, the bottom line. I have also perused the application and all other materials placed on record with it. I have also perused the judgment, etc. From the the learned trial court is forming the opinion that there is a prima facie case. From the perusal of the above, it is evident that there was specific directions to respondent number 129 by order so and so regarding the applicants therein to be allowed to contest the election and the other party be barred from participating. The report of the official election observer and orders of the Deputy Commissioner and Superintendent of Police makes it evident that the order so and so was not complied in toto by respondent number 129. The said violation was even after several interventions of the said authority. So, from the above, it is crystal clear now that the prima facie case is established. My lord, the problems which I have shown and the requirement of law as laid down by the Honorable Supreme Court in Kalyan Kumar Gogoi judgment has not been discussed at all, that which way it should be done, what about the risk, etc. Now, so far as the other two factors are concerned, my lord, Lord will kindly see, as thereafter, my lord, and as submitted by Learned Counsel for the applicant, that the non-intervention of the court could result in irreparable loss by the applicant, as the same cannot be compensated in monetary terms. It is seen that applicant stands at losing his rights, which otherwise would have accrued to him had the election were conducted in a fair and proper manner. And allowing the other party to enjoy the fruits of the illegal act by prejudicing the rights of the applicants would be travesty of justice. This right cannot be compensated by bestowing upon the applicant by declaring the matter in his favor upon final adjudication of the suit at such later stage. Nor can the applicants be compensated in monetary terms later. Thus, it is also evident that the applicants have made out a irreparable loss and injury. Is it the correct way of approaching it? With all my humility, I'll submit. Here, the learned court below ought to have discussed that if the injunction is granted today, who will lose? And in terms of the mandate of the Honorable Supreme Court in Dalpat and in the my lord, that other judgment of Supreme Court, my lord, that Palani Swami. You have not discussed, learned trial court has not discussed all these things to arrive at the finding that there is the issue of irreparable loss and injury is in favor of the plaintiff. Then next, my lord, this court also has carefully weighed and considered the harm that would befall on the other party if the injunction is granted in favor of the party. This court is also not oblivious to the harm the respondent faces if the injunction is granted in favor of the applicant. At the same time, it is now also aware that the respondents have placed themselves in the way of harm by their own doing, violation of the court's order dated 14/11/24. By an act of their own doing, they have also prejudiced the rights of the applicants as rightly opined by the counsel for the applicants. The respondent ought to have complied the aforesaid order unless intervention of the appellate court. Non-intervention of the court in this matter would only legitimize the illegal act of the respondents by which the respondent number 10 has come to find himself in the position to begin with. It appears that the applicants face more harm if the injunction is not granted in favor of the aspirants. And relevant considerations as laid down by the Honorable Supreme Court, which I have referred to, my lord, have not been discussed at all. The learned court did not discuss that which way the court is running more risk, number one. Learned court did not discuss that whether in this case, prima facie, does it appear that the court is going to, the plaintiff is going to get the decree? Where is the presumption that all those 50% will cast their vote? These things should have been discussed. There is no matter in the plaintiff, my lord. There is a presumption, my lord, that if we can show that there is a violation of order dated 24/11, I am repeatedly saying that nobody is allowed to violate the court's order. Otherwise, this system in which we are living will not remain. Everybody has to honor the order passed by the court until it is disturbed, set aside, or modified. We have to comply. I am now not for a single moment saying that court's order can be violated. But fact remains that in a suit where the honorable court is deciding the question of a temporary injunction under Order 39, Rule 1 and 2, court has to be governed and guided by the principles laid down by the Honorable Supreme Court in the matter of grant of a temporary injunction. Here in this case, when a learned trial court has lost sight of everything, and so far as the First Appellate Court is concerned, since the trial court's order was only based on the violation of the order dated 24/11/24, the First Appellate Court said that for violation of that, you have already filed a petition that is yet to be decided. And before it is decided, how can the court predetermine the issue and record a finding on the basis of a presumption that it was violated? That is the case, my lord.
No, it's
So in my
because of certain conduct.
Yes,
How that
I never
how the election
I
was
never
actually-
approve of that conduct, my lord. If it was violated, it cannot be supported by any means. That I am not for a single moment saying. Court's order, my lord, has to be obeyed until it is disturbed by a higher court. Every person in the society should have full respect for the court's order, my lord. Otherwise, this system will not, this system will collapse. We are living in a system, my lord, in democracy.
Yes.
So that being the position, my lord, lordship has to see that today, my lord, that if the first April court's order is interfered with, then if the trial court's order is revived, then the court will see whether the trial court was right in passing that order. If not, my lord, your lordship will not grant them any temporary injunction because he has been elected. He can be deprived because there is no question of materially affecting his election. There is no allegation in the plaint. This suit is never going to be decreed. That being the position, my lord, this revision petition is liable to be dismissed. Apart from the fact that this is not maintainable in law, my lord, because it's a petition under 115. That's all.
May I please? There was some delay.
And I'm
my
deeply,
lord, on
I'm
factual
deeply obliged for giving me such a patient hearing, my lord.
Well, since there was some dealing,
Hmm.
so on factual aspect only.
Oh, for this, he's appearing for one, I think.
One only.
He's also appearing for one.
No, this is like, I mean, there was
There was
some
some
delay
delay.
case, so what is that?
My senior sir, when he submitted that there was no any allegation against this respondent number 1, my lord. Is because, my lord, in earlier suit, this respondent number 1 was not a party. Even in the contempt application, this respondent number 1 is not a party. This is in between the two groups, which my senior brother has said. The fighting is in between two groups. Whatever violation that was done, it is in between respondent number, dependent number 1 to 8. In that suit, I am 10, this respondent number 1. I am nothing to do with those violation of the court order, my lord. And we also, my lord, discourage if there was a violation, that order 39 rule 2A misapplication, my lord, it was hard on 4th December. And they should be punished if it is violated, my lord. So
you are not part of it.
I am not part of it.
That's what you're.
We contested, petitioner, both of us, we have contested. Petitioner also not a party in that earlier suit. But after he lost the election, he enjoined in this new title suit with that earlier to plaintiff in that title suit.
So, I mean, now, when was it over, election? You were elected when?
29/11/24, my lord.
29.
Declaration of result, my lord.
29.
Declaration was on 29/11, my lord.
My lord.
Since then, you are in the help circuit.
My lord. Hello.
You are appearing for?
I'm appearing for 2 and 6 to 10. 2 and
the election officers.
Yes, my lord. I am the chief election commissioner and the election official. Other than 3, 4, 5.
So election officials, I mean, your role.
My role, my lord, of course, just I will. Some things have been said about. Some things have been said about the chief election commissioner and the other polling officials changing sides by my learned senior, appearing for the respondent number 1, who was earlier appearing for 3, 4, and 5, my polling officials. Now, my lord, in this title suit of 21, my lord, what had happened?
I mean, injunction was against you, right? Initially?
Yes, ma'am.
In spite of the order, I mean, you allowed it to go ahead.
My lord, we have.
Then you did not comply with DC's order, you didn't comply with SP's order.
Of course, that part, my lord, we have in the, before the learned trial court, we have made our affidavit, ma'am. And one thing has been said where my learned senior has said that we changed side, my lord. But what happened, ma'am, in title 21, this is a factual aspect, my lord, otherwise. What happened? We engaged one counsel, my lord, and that same person was engaged by the defendant number 10 as well, my lord. Same counsel, my lord, in that title sheet 21, my lord.
Lordship will take note of
Now,
this is very serious.
No, my lord, what
Uh,
happened?
What happened, title suit 21,
Yes,
the same counsel was appearing for defendant number 10 as well as you.
1 to 9. Yes, 1 to 9 were the election officials. Now, what happened in our
One
affidavit?
second, as well as 1 to 9,
9, my lord.
all election officials, right?
My lord.
Hmm.
Now, in our WS,
So there was some conflict of interest.
conflict of interest as well, my lord. And what happened was that my WS, my lord, which affidavit I had sworn, in the entire content, my lord, it is from of the defendant number 10, my lord. In my WS, it is said, I am the elected person, I am this, and so it's all being said about the defendant number 10. So we brought that to the notice of the learned trial court, my lord, JMFC, and we filed an application under order 6, my lord, for amendment, my lord, and it was subsequently allowed. So we had to amend it because that could not have been my WS, because in the WS, in my WS, it says I won by this vote, this number vote, I am the elector. So that was that. So that was the reason we had to amend that application, man. And we of course sought the leave, man. Now we have admitted as such that of course we have tendered our unconditional apology also before that hearing is done, man. Now today on just factual aspect, I'll take your lordship to the plaintiff, man. It was very unfortunate, of course, that the situation was such we could not comply, man. That we were, of course, our personal life and liberty was also at threat, my lord. There was a threat on our person, my lord. Not as such by the person, but their situation as such that, and my lord has seen the bylaw also, my lord, where I have the entire responsibility for the peaceful conduct. So somehow we had to conclude that thing. Now here, my lord, just I will take your lordship to some 2-3 paragraphs of the plaint, my lord, because I'm just bringing the facts, my lord. Because my learned senior has said that there's nothing on the plaint, my lord. That is why, my lord.
Yes, where is that?
Plaint, my lord, it is at the title suit.
Page.
Page 38, my lord, of the paper, my lord.
38.
38, yes, my lord. It starts at page 38, my lord.
So allegations against defendant 10. Defendant number 10.
No, yes, my lord. The pleadings as such were the Land Council for the
Correct, page 38.
38 it starts, and my lord will come to page 39, my lord. My lord, this is the plaintiff, my lord.
39, yes.
39. One is the contesting candidate, and then under number 2 and 3, my lord. These are from the branch students union who were allowed to supposed to be supposed to be included. I did not include because of the situation, prevailing situation. Because of the situation, I did not allow this petitioner number plaintiff number 2 and 3, my lord. Otherwise, here in this title to 21, these 3 persons they are together, my lord, as plaintiffs, my lord. So, my lord,
So you did not allow respondent 2 and 3.
2 and 3, my lord. They are delegates 2 and 3. They are the president and general secretary of the branch students union, and they are delegates, my lord.
They were supposed to cast vote.
They were supposed to cast vote as per the direction of the court, my lord. Now, this here in this title to 21, these 3 have come together as the plaintiffs, my lord. Meaning thereby that these persons and their delegates are the supporter of this number 1 plaintiff number 1, my lord.
Okay.
Now, if your lordship would come to page 56, man. Para 24, man. I'll just read some 2-3 paragraphs, my lord, where the materials, my lord, is present, my lord. The plaint in
56 para
24, my lord. Para 24, my lord, I will just of this paragraph 1, 2, 3, 4, 5. 5th line from the bottom of para 24, my lord. The names of the official, my lord.
Yes.
The names of the official candidates of the plaintiffs were deliberately rejected, and on the contrary, the candidatures of the rival party were accepted. They also blatantly and openly denied extending voting rights to the delegates of the plaintiffs. Now, your lordship may come to para 30 at page 58, my lord.
38.
58, my lord, para 30, my lord, 30 and page 58, my lord.
30. Okay.
30, my lord,
30, yes.
page 58, my lord.
Mhm.
That the actual voting process of the election commenced on so and so at Siddhartha Hall, Itanagar, and concluded on so and so. Since the day one, the plaintiffs, my lord, plaintiffs repeatedly approached and requested the defendant numbers 1 to 8 to allow their delegates, total numbers 51, to participate and exercise their civil right to vote in the election in place of the delegates, total numbers 54, selected by the rival party, and prohibit the latter from voting in the election in terms of so and so. Injunction order dated so and so, and the subsequent order dated so and so, but without any avail, as they were adamant not to abide by the order of this honorable court. And now page 32, my lord, at page 61.
Para 32.
Yes, para 32, my lord, page 61. my lord.
Yes.
Para 32. That in view of the orders, it is so and so of
Where,
this
where,
on
where? Para
para
30.
32, my lord, page 61, my lord. 61.
The
Down
paragraphs are wrongly numbered.
page 61.
See, come to page 60. So para 32 is there.
Yes,
Two para 30.
So page 61.
61.
61, 32, yes.
31, page 600. That you on the orders dated 1411, so this is the injunction order, and so of this honorable court, the petitioners and the delegates, after seeking permission from the superintendent of police Itanagar, made an attempt by entering the gate heading towards the Siddhartha Hall election venue to participate in the election process, but was thwarted by the supporters of the defendants and the rival party, and they were severely beaten black and blue with lethal weapons, causing severe bodily injury. The plaintiff number 2 suffered serious head injury and had to be immediately hospitalized. The incident took place in the presence of the police force, but despite repeated requests, they failed to ensure the compliance of the order of this honorable court. Thus, the plaintiff's delegates were prevented from exercising their civil right to vote in the election. Now, in this paragraph, you will also have seen, my lord, it is the plaintiff's delegates versus the rival delegates. Now, in this paragraph 24, 30, and 32, though the name of the rival has not been mentioned, my lord. In para 34, it has been revealed who is the rival, my lord.
Okay.
Para 34, my lord, at page 63, my lord.
Kneel of the coffee.
These earlier preceding paragraphs, my lord, as I've submitted, my lord, plaintiff delegates versus the rival delegates. These persons are the 3 persons are the plaintiff, and the 51 persons, they were supposed to be the voters and supporters of the plaintiff number 1. Now 54 rival delegates, my lord. Now who is this rival delegates, my lord? You'll see at page 63, my lord.
What is the rival's name?
That is revealed here, my lord, at page 63. Who's the elected now?
No,
leader?
legend is fine, but
Yes.
but your I mean 2 groups are there.
It is the other group, Reta.
Reta. Correct. So Reta
No,
is
selected by the rival, yes, that I'm coming, man. 34 is, my lord, is there, page 63.
Yes.
Be that as it may, as per the records, there were 5 contestants for the post of president, and once Legend Gary secured so and so votes has been declared elected, while Sri Ashok Doka, the plaintiff number 1, has secured so and so votes and has been defeated by the margin of 91 votes. It is pertinent to state that out of the 91 votes, 54 votes of the delegates of the rival party are illegal, as they are prohibited from participating in the election process by this honorable court, and they are the supporters of Sri Legend Gary, who was also fully supported by the defendants. So here also, in the plaint, my lord, it is said these 54 are the supporters of the defendant number 10, my lord, and the 51, my lord, these are the supporters of the defendant plaintiff number 1. That much only I wanted to point out.
My learned friend has put the final nail in the coffin, lordship. After he has argued, I shut my mouth, lordship. In fact, Lordship, while hearing the argument of the learned senior counsel, when he said that it is some mere illegalities only in violating the court's order, I thought that it's nothing but mockery of majesty of the court, my lord. It's very unfortunate, my lord. If it is the mere illegality, my lord, I'm sorry. I'm sorry to say that this is nothing but mockery of majesty of the court. If it is mere illegality, my lord. After the DC's observation, after the SP, after the all these lordship, if it is the mere illegality, my lord, it is nothing but mockery of majesty of the court.
I have not argued that.
Yes, mere illegality, I have written when he said. I have written that. Let us see the recording. Let's see if it is
My lord,
not
injunction
there.
violation
When
is
he
one
said
thing.
It is mere illegality.
My lord, injunction
When he said
violation
it
is
is
one
mere
thing, injunction
illegality,
is
I have
another thing.
recorded. Okay, it is on the record. Now, Lordship may first come to page 126. Oh, no, 324. It is page 324, Lordship, in the paper book. Because some direct question was not answered, Lordship, that is why I have to show. Lordship's query.
Page.
Page 324, paper book number 2. Knowingly or unknowingly, my lord, it is not shown. Let us show. Lordship asks a pertinent question that how the delegate was sent. How many delegate?
Yes.
Lordship at 324, Lordship get it. Serial category of institution, total number of delegate. Lordship, the branch students union, 20 delegate. Higher secondary school,
5.
5. Secondary school, 3. So there is no middle school. Now, Lordship, please come to page 496 of the revision petition, Lordship. No, not here, Lordship. Lordship, that document is not here in the paper book, Lordship. Page 496.
Page 496 of?
This revision.
This document starts at page 495.
496.
How it is 54, Lordship, and our 51, Lordship will get the answer.
Yes.
Lordship, it is started at 495. It is from the Chief Election Commissioner to the Chief Election Commissioner. It's a notification, approved delegate of so-and-so. Lordship, get it?
Yes.
It is the rival faction is sent. Lordship, at 496. Down below. Lordship, get it?
Yes.
Serial number, government secondary school NL so-and-so. This Dado Tapung, Tai Sierra, and this Tai Tigam. This school was not there. This is extra, Lordship. This 3 is extra. This is actually a middle school, Lordship.
That's why we did not send.
But it is even at a government secondary school.
It is shown as a government secondary school. It's a middle school. So that is why their list is 54, our list is 51. So this is the way how they are sending the list, Lordship, the delegate.
Our list is at 431.
Our list, Lordship, will get at 431 of the revision. Lordship, just take note, Lordship. Page 431.
My list was the second place was 51.
Since that is a middle school, we have not sent the name of that school.
Hence,
Okay. So, I mean, that's why their number has gone
Yes,
to
yes,
54 and yours is 51.
So that is Lordship's query. So that is why I have shown from the document. Now let us go one by one. First, he has said that the maintainability revision petition lordship on the day one, it is clear after the 104(2) lordship, nowadays the revision under 115 is not EA lordship, it is the 227 lordship. It is direct lordship. But this is the Supreme Court said that it can be always converted lordship and that is not the EA lordship, any fatal EA lordship. 2004, it is the collateral power lordship. 2004 SCC online, page 601, para 11 and 12. Lordship, I will not read all this will take time, Lordship.
Just para?
Para 11 and 12. Yes, direct on the same year, Lordship.
Yes, please, that been clarified.
And Lordship, my learned senior friend has referred to that judgment, that has been clarified in this judgment, Lordship.
Okay.
In this judgment, that judgment is clarified, rather.
Para 11
and 12.
It was from 2004.
Yes. Now, Lordship, he has referred to that year, Lordship, that has been clarified in this case, Lordship. Now, Lordship, the Dalpat Kumar is referred to, Lordship. Lordship, may please take the Dalpat Kumar. That
Dalpat Kumar has referred to this one.
No, Lordship,
This has referred to Dalpat Kumar.
No. My learned friend has
Dalpat
referred.
Kumar is from-
27 is the year, not the 115, Lordship.
Yes, Dalpat Kumar is 1992, right?
That is regarding the other thing, Lordship.
So
2003 6 SCC 375. That has been clarified.
Lordship will get it. This Lordship is this judgment. Lordship 2004 SCC online Lordship has taken. Lordship in the last but one page, Lordship. In the down below, Lordship, you can see 2003 6 SCC 675. It is third and that has been clarified, Lordship, for that judgment. That was placed, my learned friend. Para 11, Lordship.
2003.
2003.
6 SCC.
6 SCC 675 was referred to, Lordship.
No, which case is this?
He has referred, Lordship, that the Surya Dev Rai. First judgment he has referred.
Surya Devi Rai's case.
First judgment, Lordship, he has referred, Lordship. Revision is not maintainable, Lordship. Regarding the maintainability of the revision.
Yes.
So that, Lordship,
No, that
para
I
11
wrote in a different sheet.
12 has-
I could not-
Yeah, clarified in this judgment.
Yes.
Now, Lordship, may please come to Dalpat Kumar. Let us go by one.
Next, why the Supreme Court vacated things then?
Now, Lordship, in the Dalpat Kumar, all the paragraph has read, but one line has left. Lordship, may please come to page 722 in Dalpat Kumar.
1992.
1992 1 SCC, page 719.
Paragraph?
The paragraph, Lordship, 6, the last line. It is just the above the paragraph 7. The last line of paragraph 6 at page 722.
Paragraph 6.
Last line of paragraph 6 at page 722. Just above the paragraph 7. The respondent can be adequately compensated on their success. That is the consideration before the Supreme Court in Dalpat Kumar. And Lordship, that is a property matter. Dalpat Kumar and Lordship, this is the line. And Dalpat Kumar, there was 4 times there was against the EA, Lordship. There was in the injunction application, Lordship.
Lost in that 4 times.
Because the SLP petitioner, they have lost the injunction 4 times, Lordship, before they came to before the Supreme Court, before the High Court and here. And the Supreme Court in this case, that the respondent can be adequately compensated on the successes.
But this is, I mean, that is correct, but like this
The rest of the thing will go in my support, Lordship.
para 4 and 5, the ratio.
Yeah, the ratio is in my favor. is directly in my favor, Lordship. I'm
My
thankful
lord,
to my learned friend. Yeah, I'm
My
thankful to
lord,
my learned friend.
my lord,
Lordship,
it does not speak about property, it speaks about right also, right to my office.
Yes, yes, yes.
My learned
That
friend
two
should not
paragraph is
confuse.
directly in my favor. Yes, yes. That two paragraph is directly in my favor.
It
I'm
is in
thankful,
my
Lordship,
favor, my
to that.
lord.
Lord,
That is fine.
Lordship,
My
It is fine,
position
but
has to
only
be
thing is that,
maintained. My
Lordship.
status quo has to be
only thing is
maintained.
that, I mean, only thing is that, I mean, this is a ratio laid down.
My lord, my lord. Absolutely,
Irrespective
my
of
lord.
it.
Absolutely, my lord. It's
Yes,
a
yes.
ratio. My lord,
Yes.
so far as my friend is
हे कोई लोग মাজতে এনেকে কৈ থাকিলে মোৰ দিগদাৰি হ'ব।
no, you complete.
Let him finish, my lord.
No, I mean, you complete now.
Now, Lordship, this 2023 SCC online SC 177.
Need a reply.
The last line of para 84. Why the division bench judgment was upheld by the Supreme Court, Lordship will get at the last line of the para 84, just above the para 85. Page 60.
Page 60?
Page 60, just above the para 85. You are in the same footing, Lordship.
85.
Para 84, Lordship, just above the 85, Lordship. The last line of the para
Division
84.
bench of the High Court.
Yes, the division bench of the High Court, in our view, has rightly looked at the substance of the matter and realities of the situation. Yes, Lordship. Lordship, you have to look into the realities of the situation, Lordship. What is the reality of the situation? The vandalism, the violation of the court's order, that is the reality of the situation. When my learned friend has said that there is a life threat to him as an election commissioner, Lordship, he has filed an affidavit before the court. One should be ashamed, Lordship, after that, to argue a case, to send a party one time to appear for someone, then one time to appear for someone. He has said, my lord, there, why you have to send the written statement? He have to resend the written statement because the same council for the elected candidate has filed the affidavit, Lordship, on their behalf. On the same council party, Lordship. Now, Lordship, the Kalyan Gogoi. It's a representation of people act, Lordship. And there is nothing what, that was not my argument. My argument was the electoral roll. It was manipulated. And how it was manipulated, Lordship has seen.
Electoral rule of the way ladder.
If Lordship in this whole year, Kalyan Gogoi case and Ashutosh Agnihotri, Lordship will get a single word with regard to the electoral roll, preparation about the electoral roll, then Lordship can rely. This is under 101C, 100C, Lordship, the Representation of People Act. This has nothing to do with my fact, Lordship. And it is a polling station was sent. Like I am in Kumarpara, Lordship. My polling station is Horipia Vidyapit, but my police station is taken to Aizha Vidyapit College. So I cannot go there. So there 300 votes, there was a difference of year, all that.
That was the fact.
That was the fact of this case, Lordship. There is nothing to do with this year.
No, he was talking about the probabilities. I mean, basically.
My case is not that, Lordship. Until yesterday, I am saying that. My case is not that. Nowhere, my lord. That
My
is
learned
not
friend
my
is not
case.
answering my query.
Not required to answer this query.
I am not here to answer his query, Lordship. I will answer Lordship's query, Lordship. I am not here to answer his query.
But you have to answer my point, sir.
Okay, okay.
Point I have raised, my lord.
That is why I am here. I am giving reply one by one.
My reply
While
on
you are,
presumption.
while you argue, I talked to my junior, you objected there. And now when I started argument, every line you started here. I know your tactics. Be patient, keep patience, keep patience. Already
Yes,
you
yes.
have enjoyed.
Yes,
Yes.
yes.
Already you have enjoyed illegally for long time. Now, Lordship, may please come to page 323 of the paper book 1. No, it is paper book 2, Lordship. Who is Mr. Soki? Let us see, Lordship. After Mr. Stoki has argued, actually, I do not have to argue, Lordship. One should be very ashamed of all this, that what happened, this Soki has very clearly said that money plays, Lordship.
Page 3,
323. Electoral college, my lord.
Yes, yes.
It is Roman 3. The electoral enrollment committee shall be the delegate registration committee to enroll and register the detailed record of delegates and prepare the specific method of electoral roll for the delegates to enable them to vote in the general conference of the union.
Page 160, sir.
Lordship, may please come to
Page 160.
160,
Para 11.
para 11.
Electoral Enrollment Committee Association.
160 of?
160 of this paper book, Lordship.
Book 1.
Paper book 1.
What is there?
The WS of the Electoral Enrollment Committee.
The WS of the electoral enrollment committee, Lordship.
The initial one, the later one?
Later one, Lordship.
Actual one.
Actual one, Lordship. The earlier one, the person has taken money from his client and filed it for the others.
Okay,
And someone dictation.
Page 160.
160, para 11.
Yes.
That as regard the statement made in paragraph 29, 30, so and so in the title suit, the deponent states that the deponent, for the sake of repetition, related the stand that the deponent have limited role in the whole election process, which was for the purpose of enrollment of delegates and submission of final list, which was duly carried out prior to passing of the order dated 14/11/2024 by this honorable court. However, the deponent begged to clarify that the respondent defendant number 1, being the chief election commissioner and the then ANSU president, in terms of the ANSU constitution provided under the Article 21, wherein the president ANSU and constituted the election committee, which has the responsibility to conduct the election, wherein we were not the members, although we the deponent to have a better clarity in the issue before this court, also obtained the polling registration number 3, polling register number 3, where the names of the voter who have casted their vote and after perusal of the same found that the name of the voters from serial number 5682 to serial number 5736, who are also defendant in the instant title suit number 17 of 2024, arrayed as defendant number 9 to defendant number 63, and they have casted their vote despite being serious dispute and controversies raised during the enrollment process, for which we have excluded their name in the list submitted by us on 9/11/24 Annexure 2. Lordship, may please come to page 1244 in the additional affidavit. In the additional affidavit filed before this court, Lordship, in the revision petition. Polling register is before the court now, because along with the written statement, they have annexed this. I am grateful to my learned friend. How the Zangal law was there with the help of some here that go ahead. Page 1244. Whatever you want to do, we will protect you. There is no problem. Do anything, whatever you want to do under the sky. Page 1244 in the civil revision, the additional affidavit, Lordship.
The part relevant part of the polling register.
It is the relevant part of the polling register, Lordship. It started 568283. 56.
5682.
Yes.
Tai Yake.
Yes. From there to
5736.
yes. No.
57.
57. 5736. my lord.
Tai Galom.
Yes.
These are all dependents in title suit 17 who are barred from participating.
And they are dependent in title suit 17. And they were barred from participating, Lordship, by a court order. This shows how desperate they are to hold the presidency here. Anybody, if you want some more question to answer from my side, I'll give, Lordship. This is the conduct. This is the conduct, and this is how the election was conducted. And this election to be protected by the court. Now, today, many things has been argued. Whether all these things are there in the order of the appellate court, Lordship. What the order of appellate court, I have read only one line. That the prima facie case is not there because the violation is there is a order 39 rule 2A.
How is that?
Today, it is representation of people act, all that has gone, this counting, mathematics, all these are good. Whether it is a part of...
So now your case is that these people have actually voted for this Tenzin.
Yes.
Yes. Legend
Tenzin, or whatever. What is his name?
Legend Gadil.
Legend. Yes, Legend.
My lord, there is no material.
My lord, my point is to whether to whom to vote or not.
1 second, Mr. Majumdar, what about this register?
Which register, my lord?
The register they have referred to by filing an additional affidavit. They have brought some pages of a polling register.
Enter register.
The register. So wherein these people have been shown.
My lord, this honorable court, that is what, my lord, that is why the Honorable Supreme Court has repeatedly said that in a temporary injunction, there is no question of a trial. If any document is to be relied as an evidence, then there has to be cross-examination, there has to be opportunity to the other side. Whether this evidence can be accepted at this stage, it's not a part of the plaint. Had it been a part of the plaint, there would have been a reply in the written statement. Today, at the revisional level at High Court, my lord, they submit some document and say that as an additional affidavit, he accepts it. I don't know, my lord, what is that document. I have not seen that document till now.
Oh, okay.
Now this has been filed in where? This has been filed.
No, he is now today only he is appearing for the one, so how he will come to know?
It has been filed
in the month of
long back, Lordship, long back.
Elsewhere, it has come in the month of May before this honorable court. It is
And otherwise also it is filed long back.
Thereafter, on July they have
additional affidavit copy was served.
This was before the trial court, right?
Yes.
No. In the month of July, my lord, they have filed it, and that has come along with the written statement of other defendants, not by the plaintiff.
No, that's correct. But the court which has passed this, order vacating this interim injunction.
It was not before
It was not there.
It was not.
It was before which court then?
It is recently only they have filed, my lord.
Recently means when?
In the month of July 2025.
One second.
And LCR has come in the month of May 2025, my lord.
When the revision is pending before this
No,
court.
LCR has come, trial court record has come before this court in May. And this was filed in the month of
July. And that was not under the consideration by the appellate court, my lord. This is subsequent.
No, this is. One second.
But this additional affidavit just now
before
has
the
been
revisional court by filing an additional affidavit, Lordship.
Before the civil.
Yes.
No.
For the High Court.
High Court only.
Before this High Court, Lordship. We have annexed that. Because this was filed before the trial court.
No, that's what I'm saying. It was filed before the trial court.
Yes.
But the record was already called for, so it could not come.
Yes.
So you have filed an additional affidavit to bring on record.
Yes. So it was filed before the Court of Civil Judge on
filed here,
23/6/25.
36?
It was filed on 23/6/25.
23/6/25.
And that is why yesterday I have shown Lordship that subsequent event judgment Lordship, 1975 Supreme Court Lordship.
To this, I'll give a reply, man.
Lordship. Okay, let him give a reply, then I will stay here tomorrow. I'll give his reply.
No,
Lordship.
right now,
Reply
I'm
to
giving.
replies there, Lordship. If the
My
Lordship,
lord,
I
in
have
the additional
I
affidavit-
placed it yesterday. I placed it yesterday. This was filed long back. The other side has received this copy on 5/7/26/25.
My
And
only-
today he said he has not seen this.
My lord,
And
my
now he
only
wants to give a reply.
My lord, my only response to this is that you have said nothing about this in the plate. In the revisional stage, if you can show some document, can the order passed by the first appellate court be, my lord, challenged on the ground that some document
Yes.
I'll file before the
Yes.
High Court,
Yes.
and on that basis I'll
Yes.
assail the order passed by the first appellate court. Number
Yes.
one. Number two, my lord, unless they amend the pleading, they cannot rely on any document beyond the pleading, my lord. This is not a part of the pleading. How can they argue all these things, my lord, by filing an additional affidavit? This is a civil suit, my lord.
Whatever not there before
In a
the
civil
appellate
suit, you
court,
are
all
not
has
entitled to
argued
file
before
any
the
document in the
revisional
High Court.
And now
You have to
he's saying
file
that
your
the
pleading
appellate
before
court
the
has
trial
ruled it.
court. Before
He
the
can
trial
argue
court, you have
anything
not
and
filed
everything,
anything.
but he's not
Today,
the-
you are bringing some document in the revisional stage before the High Court, and you rely on it. It's not a part of the pleading. They are arguing beyond the pleading.
They finished court there.
No, it was the Mazumdar.
My lord.
It was before the trial court.
No,
This
my lord. What
document was
I'm
filed before trial
no, my
court.
lord. What I'm saying is, my lord, prima facie.
Pleadings, it is there or not there, we have to look into. But as far as record is concerned, it was there before trial
My
court.
lord, my
Because
lord,
they have filed it.
my submission is before the trial court in the pleading. This is not part. If they amend the pleading, then we'll have to give a reply. Then only your lordship can decide. They have brought it in the High Court, some document that
My lord, what
this
is going on, Lordship?
No, one second.
My lord,
In
written statement, someone can file a reply.
in
Trial court.
in
I'm learning, my lord, all these things.
in title suit number 21 of 2024,
My lord.
a written statement was filed by the defendants, right?
My lord.
Yes,
And
ma'am.
there, this has been specially pleaded.
In the written statement, my lord, by dependent number who subsequently changed their stand, they have brought this document.
No, correct. They have brought this document, whatever written statement has been filed, and that is there before the court.
That is now there before the
That
court.
before the
But
court.
then
That's what
when
I'm
the
asking.
appellate court was considering the matter, it was not there.
That's not-
Then
But now it is there.
Now it is there. And then, my lord, they have filed
So,
one
my lord,
IG also.
I want to finish my case, Lordship.
Yes, yes.
Lordship, I go by the Delhi Development Authority, Base Keeper Construction Lordship, para 17, para 19, para 21.
That was referred to yes. No,
Yes, I have given the document, Lordship. Only, Lordship, I have not read yesterday because, Lordship, many now the raising voice is there. So let us see what the Supreme Court said for the violators. What the Supreme Court said, they who violate the court's order, how to treat them. How to treat the violators of the court's order.
which was the
At the Delhi Developed DTS Keeper Construction,
correct.
DTA
para,
versus Keeper
para.
Construction, para 17,
Hmm.
para 17, 19 and 21.
We have an extra copy.
I have an extra copy, Lordship, I can give it.
I think it was given to us.
Yes, I have
No,
given
it's
it.
fine, it's fine.
I have an extra copy. The contempt, sorry. Lordship, may please come to page 635 directly. I'll not take time, Lordship. Barkandas is waiting. 635.
Yes.
The contemptor should not be allowed to enjoy written fruit of his contempt. The principle that a contemptor ought not to be permitted to enjoy and or keep the food of his contempt is well settled. In so-and-so versus so-and-so discord held clearly that undergoing the punishment for contempt does not mean that the court is not entitled to give appropriate direction for remedying and rectifying the thing done in violation of the orders. The petitioner therein is given an undertaking to the Bombay High Court and they had acted breach of it a learned single judge was then guilty of contempt and imposed a sentence of 1 month imprisonment. In addition thereto, learned single judge made an appropriate direction to remedy the breach of the undertaking. It was contended before this court that the learned judge was not justified in giving the opposite direction. In addition to the punishment of the petitioner for contempt in the court, the argument was rejected, holding that the single judge was quite right in giving the appropriate direction to close the breach of undertaking. Lordship, para 19. To the Lordship, the para 18, another the Supreme Court judgment, it was quoted, Lordship, in the violation of contempt.
Yes, it is.
So I'll not read that. Para 19, Lordship. To the same effect, at the decision of so-and-so and so-and-so, so-and-so, who the full bench of the Madras High Court that where an act is done in violation of an order of stay or injunction, Lordship, as in our case, Lordship, it is the duty of the court as a policy to set the wrong right and not allow the perpetration of wrongdoing. The inherent power of the court, it was held, is not only available in such a case, but it is bound to exercise it to undo the wrong in the interest of justice. In the interest of justice. The Lordship will not shut his eyes, Lordship, when all these illegalities, and in black and white, Lordship, Deputy Commissioner, Superintendent of Police, all of them is given. After that, Lordship, I don't think Lordship will shut his eyes. Lordship, yesterday I have given the 75-1 SCC regarding the subsequent development. I have given, this is my copy.
Also given. I have
Yes.
got it.
So at this stage, Lordship, Lordship, one thing is said that he will go, my client will enter, my client will take as a president. No, I have not asked for that in an injunction. There is a clause in the Constitution, Lordship, that if the illegalities are there, he will go. The Vice President will take charge. In the Constitution, I can show directly, Lordship. In the Constitution, there is a direct clause, Lordship, on that.
Which paragraph?
Lordship, at page 308.
308.
Lordship, please come, page 308. Why all these things are arguing, I do not know, Lordship. That I will take this as. Why I will take this as? It is page 308.
The Vice President, clause 2.
It is the clause 2.
No, otherwise also it's not a question of taking charge.
Yes, no, it is argued, Lordship. That is why I said that why he will send and I will enter into this. He's so no. I don't ask for that. I'm not there. I'm grateful, Lordship, for the pleasant hearing, Lordship.
My Lord, one short reply, just 2 minutes.
Then I have to give reply, Lordship.
No, my Lord, this additional affidavit, they are saying that some persons have, these 54 persons who were illegally allowed to, if their argument is, if these 54 persons who were illegally allowed to cast their votes have actually cast their votes in favor of the returned candidate who has won the election, then, my Lord, my submission only will be number 1.
Yep.
If your Lordship,
He has not argued that. He has not argued that.
No.
You
Your
have not
argument.
argued that. No, this is not my argument. I have not argued that. You are wrong. You are giving a wrong reply. I have not argued that. That is not my argument, my lord.
No.
I have not argued that.
No.
Alright, bhai, this is your in favor of you, sir.
No. Let it be my favor or not in my favor. No, I don't want that. Lordship.
No. Only thing was that, I mean,
This is.
it has been pointed out.
My Lord.
Pointed out to this court that
My Lord.
all these people, I mean, whose name was there in the polling register,
My
they
Lord.
were also part of the.
That's that. Lordship has understood my point.
My Lord.
My learned
My
friend has
Lord.
wrongly understood my point.
All right. Please give me 1 minute.
Lordship understood the thing very thing.
Lordship will give me 1
That's the
minute.
point.
Lordship will give me 1 minute.
Yes.
That is the
Sir,
point.
may I give a reply?
Yes, please.
My Lord, if the argument is that there is a document which shows that these persons were allowed to cast their vote only and not in whose favor they have cast their votes, then my reply will be that where is the presumption, my Lord? There is no reply to this argument I have made. My learned friend is not giving a reply that where is the presumption that if these persons were allowed to vote, they have actually cast the votes in favor of different number 10. That is my argument. There is no reply at all.
When your election is illegal, I don't have to.
Yes, yes.
Your question is.
No, you complete.
My lord,
You
my
complete.
submission is if they simply say that these persons illegally were allowed to cast their votes, then my reply will be, then where is the presumption that these persons were allowed to cast their votes in favor of defendant number 10 who was won the election?
That
Now,
is your
if
argument
this,
from the beginning only. Yes, yes.
yes,
That is your argument from the beginning only.
beginning. And
Beginning only you have been saying so, correct?
my lord, my lord.
Now
And
only thing is that Mr. Sharma has pointed out that these
my
people have in fact casted vote in whose favor that is not there on the record.
No, I have
then,
never.
then,
That
That is not
then,
my argument.
Holding the post
then, my lord, I reaffirm my reply that if they have cast their votes, in whose favor they have cast their votes, if this material is not before your lordship, how can your lordship presume that they have cast votes in favor of defendant number 10? To this, my lord, there is no reply. And for this, my lord, I have relied on Kalyan Kumar Gogoi judgment. My learned friend is saying that is in the about electoral roll. Question is not about electoral. Question is if they turn up tomorrow, you are saying that if your persons are allowed to come, they will cast vote in your favor. Supreme Court has said that there is no presumption. Similarly, my lord, my submission is based on that judgment of Kalyan Kumar Gogoi, that if these persons were those who have cast their votes, in whose favor they have cast the votes, where is the material, my lord?
Lordship, when someone
And-
have taken over the post illegally, he should not
And-
ask
and-
any irrelevant question.
And
When he
my
is
lord,
there
my-
illegally, he is an illegal person. He is holding a post illegally. That's my point.
My
Before
lord,
the court.
my lord,
If
so far as
he's
just
a
one-
person has fraudulently entered into a post, he is a fraud. Doing
My lord-
illegally, he violating the court's order. If someone has entered into some post, it is illegal. It is per se illegal, my lord. That is
my lord,
my
one submission
argument.
I will make. So far as defendant number 10 is concerned, my learned friend has pointed out, he is not a party. Plaintiff is also not party. My lord, are these persons party in the
Only-
order passed by in the title suit number 17? You are saying that you are taking benefit of an order which was passed earlier. In that case, my learned friend Mr. Tama will affirm whether the plaintiff number 1 is a party in title suit number 17.
No, my lord, he is not
Then,
part.
then,
Even in that contempt petition application,
and
this
that
10 is not part. Respondent
and-
number 1 is not part.
No,
Then please-
respondent number was, see, his argument was respondent number was not required because he was basically challenging the process, election process, correct?
My
Initially.
lord. My lord.
No, no.
And
Whether-
one thing my lord
whether-
has to understand.
He is a beneficiary, Lordship.
My lord,
What these
whether,
things are happening, I
whether,
do not know.
my lord, another relevant question is
Not
whether
the
defend-
benefit of
whether-
all
my-
illegally.
my lord, another important question is whether defendant number 10 was a party in title suit number 17. Mr. Tama, please confirm.
He is
No, my lord.
trying to
He is not-
continue with the argument and the pardon the matter for tomorrow. I do
No,
not
no,
know.
no, my lord.
If
One
this is
question
not
only.
the way,
This is very
Lordship, after
pertinent question,
finishing
my
the
lord.
Lordship,
My lord, if
He was,
This court time is complete. Lordship, now, so I know from the day
My
one,
lord,
Lordship, somewhere.
if I
tracking
make a
this-
pertinent reply,
No, Mr. Majumdar, Mr. Sharma has, while arguing yesterday, if I recollect properly, then he has stated so, that he was not a party.
Yes, I
He stated
clearly
so.
said that.
That like, I didn't have any
I've
grievance
shown.
at that point of time because they have basically challenged the election process. The whole process was illegal. That's what he was.
Because
You may correct me, but.
Till yesterday, till yesterday he was for the 3 and 4. Now he has taken the brief letter on Lordship, so
My
he has
lord,
not taken the note
election-
there at that
election-
time. Now
my
he
lord-
is appearing for number 1.
My
So he
lord,
has to change
election-
his argument, Lordship.
let me
So there is some
give my
confusion
reply,
there.
sir. My lord, if the election was held by a body legally, then they are challenging only the election of a return candidate. They are not saying that the body which held the election is bad. He did not have power. That is not the argument. So election was held by the competent authority.
Lordship, may I take leave, Lordship? I have completed my argument, Lordship.
Competent
I'm grateful,
authority.
Lordship, for a percentage.
And so far as different
For the
number
percentage.
10 is concerned, so far as plaintiff is concerned, they are not party in the earlier suit. So there is no question that one person is taking advantage of the earlier order passed. None of them is a party. It's not a PIL, my lord. It's a civil suit.
Yes,
And
yes.
yes, man. That's all, my lord.
I have challenged the whole election process, my lord.
You cannot challenge. Because
Yes,
there are
okay.
others who were elected, they are not a party before this court.
Yes, yes, I know. Your call, only your client can do anything and everything under the sky in Arunachal Pradesh.
In the
We
election,
cannot.
my lord, so many persons
I
have been
know,
elected.
I know.
only
Your client can do
election of
anything and
only one person
everything.
is challenged.
Your client can do anything and everything in Arunachal Pradesh. My client cannot. I know.
Both the senior counsel, the room is there. In the High Court.
Let's hope, my lord, tomorrow we join over a cup of tea.
Today he is not here, Lordship. That's my point.
The same table, in fact, the same table.
Yes,
Same
not
table.
the same table, same the next year, Lordship.
And my lord,
I'm grateful, Lordship. I'm present.
to bring on
So we
record,
close it.
to bring on record,
Oblige,
my lord,
oblige, my lord.
this one,
So, I mean, we'll
this
take-
is the,
to be fair and honest with you, I'll take some time to write this. So,
Oblige,
is
my lord,
this,
yes.
Lordship? I have not seen
Always,
it.
always.
I do
my
not
lord,
know what it is.
this is the written statement.
How can you bring a written statement?
Earlier, it is there on the record.
732.
Kindly see, my lord, this is the written statement that was earlier filed by 1 to 9, defendant number 1 to 9.
This is in the record.
Wherein, my
It is
lord,
on the record, Lordship. Page 730.
just a minute, sir. Wherein, my lord, in affidavit, this
Lordship, for the
defendant
same
number one-
person, Lordship, two person is
Okay,
arguing. For the first time I have seen one senior counsel arguing for the one person,
Yeah, I mean,
then one junior counsel is arguing for the same person. I do not know what is going on.
so this is on record, right?
This is on record, but the last part.
Something new I have seen, Lordship.
My lord,
For the
Junior-
same person, one
My lord,
senior
junior-
counsel is appearing. Oh,
My
yeah, I
lord,
know. You'll teach me. I know. But this is not the way. Then when
My-
a senior counsel is arguing a case,
My lord,
then
let me
after
discuss
he
that.
complete, a junior counsel will start the argument.
my lord, in the record, they have annexed it, but then the last verification and affidavit, they have removed it.
Okay, we'll see.
Why?
That
There is a
ought to be in page, my lord, kindly see page 131, my lord. Page 131,
Page 139 of the paper book,
my lord, revision petition, my lord.
revision petition 151.
Yeah, file there. File to there.
No, we are closing it. Mr. Singh. No, nothing is there. I mean, we'll just see like what he's talking about. I mean, it seems the document is already there. 131.
Page.
Verification.
Volume 1.
Mhm.
No, no,
What is the
131.
order?
No.
758, my lord.
Page.
Page 758.
750. That is already marked. Yes. Where? The last page you're talking about?
It is up to 772. 773 should have been the verification, and 773 ought to have been the affidavit that they have not annexed, my lord.
Okay.
So therefore, I have to submit that copy, my lord.
Okay. Is
Where
there-
in this dependent number 1, he put his signature, my lord.
Okay. It will mark out. Okay. Well, I have taken note of that.
Yes, Lord. No, see, what is they have given, I have annexed. This is not my document. They have not given to me, so I have not given it to the court. It is part of the civil appeal. It is not my document. It is their document, Lordship. I'm sorry to say that when they have served the copy
Okay, there is.
to the local council, they have not
No, my
served.
lord, since my lord is said,
These are learning, Lordship.
my lord, that issue of my change of the WS, my lord, since my lord is already there, my lord, I will just point out 2 paragraphs, my lord. One is at paragraph 12.
Yes. This is the vital point. Yes.
Paragraph?
My lord, one is at para 24, my lord.
Para 24 of?
Of this
This page,
WS, my lord, it's at page 758, my lord.
The W is condition.
Just, my lord, I will take your lordship to.
Email to copy to the extra copy.
in the main, no, not that volume, sir, Lordship. The main volume, Lordship.
Not in the paper book, my lord. The main.
No, it is Xerox copy related.
In the revision.
এইটা না হ্যাঁ এটা আছে মোক দিছিল মই কপিটা মই থৈ দিব বুলি লুজ পেজ এটা আছে ইমানটো
এইমাত্ৰ যে
জেৰক্স কৰি দিলে না এইটো না এইখন
নহয়
আৰু এটা কপি থাকিব জেৰক্স কপি এটা আছে বেছি ইয়াতকে অলপ পাতলা
এই রিভিশনত আছে কপিটো
তাত থাকিব পাৰিছে।
758 রিভিশনত আছে
ইয়াত নাই দিয়া
758
এই তাত থাকিব চেক্ৰেটাৰী চব কৰিব। Yes, which paragraph?
7 paging.
You give me the paragraph number.
Paging is para 24, my lord.
Yes, para 24, yes.
Yes, this is supposed to be the WS of defendants 1 to 9, man. But in para 24,
This one, this was the first one.
this was the first one.
Okay, here you have stated what?
Yes.
Read out.
That the statement made in paragraph number 34 regarding illegality of 54 number of votes of the delegates of rival party which were prohibited by the court and the answering defendant was supported by the defendants. Margin of 108 number of votes is vitiate with illegality, etc. are false and hereby stoutly denied by the answering defendant.
Correct.
Next slide, my lord, would see. The answering opposite party was also a presidential candidate as that of the plaintiff number 1, and he has won the election by democratic process, my lord.
The answering opposite party
Yes, my lord.
was also
A presidential candidate as that of the plaintiff number 1, and he has won the election by democratic process in pursuance of the provisions of ANSU constitution because of his goodwill among the public in general and students in particular. There is no basis to come to a conclusion that which 54 votes of the rival parties and all had secured by the answering defendant, my lord. So, my lord, this is the statement of the defendant number 10, my lord.
So,
Same.
No, I mean, you have made the statement in a different way. The
No,
answering opposite party
Yes, my lord.
Signed by him.
was
Signed by
also
of course.
a presidential candidate
Yes, my lord.
as that of the plaintiff number 1. So it is a statement by you only.
No, my lord. That what I'm saying is, of course, I signed. my
Yes,
lord. I'm not denying, my lord. What I'm saying is that in this paragraph, what has been said is that I am also a candidate, presidential candidate, similar like the plaintiff number 1, my lord, and I have won the election by democratic process, my lord.
No, you haven't said I.
My lord, let's say, and the answering the opposite party. It says the answering opposite party, my lord, the third line, my lord.
Answering opposite party
Yes,
was
that means-
also a presidential
Yes.
candidate. Correct. What is wrong in that?
No, answering, my lord, this is the WS of 1 to 9, my lord. 1 to 9 cannot be the candidate, my lord. That's what, my lord. And this is the same statement of the defendant number 10, my lord, which was just a copy paste, my lord.
Got it.
That is what, that's why we had to change, my lord. And there are other paragraphs as well, my lord. And because of that, we had to change this, my lord.
So cut and paste work.
Yes.
Maybe, my lord, because
Same
it was filed by the same council, my lord, not this present council, my lord. So same statement was of the defendant number 10, my lord, where it says the answering respondent is the candidate, my lord. Here there are 9 persons, my lord. We are not candidates, my lord. That is why we had to change, my lord. Okay.
So I don't know now whether this the cut and paste has helped you in doing this. I can't say it now. Anyways, I mean, it was pleasant. It was pleasant hearing.
My lord, it was a great pleasure arguing before lordship and against my learned friend. Tomorrow we'll join over a cup of tea. Hope he will not carry all these things happen inside to the table.
Not only cup of tea, something else.
My lord, may I make a mention, my lord?
No, not
Item number 17, today's item number 17, this is regarding the criminal petition. My lord, the notice was issued on 28, 2025, August 20. And the summons was issued, and the stay was taken on 25th of August. Until that, no one is written, my lord. There is some urgency because this is regarding the freezing of the accounts, my lord. So matter may be taken out during the first week of January, my lord.
I mean, you mention it tomorrow, no? Mention it tomorrow.
My lord, I am coming from Imphal, so that I have to leave today. That's why
Item number 17.
Yes, my lord.
You write, Miriam, you write on the prayer of the learned counsel appearing for the accused It's a criminal petition.
Yes, my lord.
For the petitioner, let the matter be fixed on. When do you want?
7 or 8 January.
Huh?
7 or 8, my lord.
Okay, 8th of January.
Yes, my lord. Obliged.
Lordship, I have a small request to put before your lordship. Item number 15 may kindly be listed for January 8th.
No, is it so urgent to make a mention now at 5 o'clock? Can't you make it tomorrow?
Okay.
You have seen it like court is exhausted, like court was hearing all this matter. I mean, it's not that urgent. I mean, if there is something to be listed tomorrow, you could have mentioned it.
Lordship.
Make it on some other time.
Lordship.